Maybe. No, you can identify one blood. Also, we must be likely to produce some certificate to do their order. I have asked them and they file it, but I not a printing date. But one time again.
Whether this is maintainable.
Milord.
On the prayer of Sri A. Rashid Learned Council for the petitioners, further time of a week is granted in terms of the earlier order. Full stop. List after a week.
Must.
May I pray for listing of a MAT appeal, my lord, for 2018 for hearing, my
Hearing will not come for hearing, it will come for orders, will
order.
for hearing.
Yes, ma'am. Any day, my lord, in the next week?
Have it on Friday next? This Friday?
Wait, with the lord. Possible MAT appeal of 2010 for listing, but the day after tomorrow,
2010 matter.
2010 MAT appeal.
Okay, we'll try for orders. Okay.
Next, Laksha, interlocutory application for listing. It is for correction of product losses. There is a defect in the restriction, and that is also reflected in the order.
Passed by this court.
Lot.
Wednesday.
Online.
May please, Lord. Question praying for listing of the CRP IO logic for withdrawal.
Wednesday.
Please, Your Lordship, I wish to mention for listing a RSA for any admission.
RSA of which year? New matter.
This year, it was listed twice, but it was left out each time.
Okay, Friday.
May I please, Your Lordship. Lordship, I beg to mention for listing of two RSA, Your Lordship. One is a fresh matter, and another one is of 2016 matter. We are the newly engaged advocate.
Okay, on Friday.
Friday.
Yes.
May I please, Your Lordship, item number 10, Lordship.
Yes.
Only the matter may be adjourned, Lordship.
Here for the appellant.
Yes, Lord.
Okay. Next week,
After 2 weeks, Lord.
after 2 weeks. On a prayer made on behalf of the appellants. List after 2 weeks. Yes.
And Lordship, I beg to mention two items for listing in order column, Lordship. 2018 matter.
Both
And-
are of 18. Both, what cases?
Both RSA, Lordship, in order column.
Order Friday next.
Wednesday, Lordship.
Wednesday we have many matters. Friday.
Yes.
Yes.
Item 2.
May please, Lord. My petitioner is a wife, my lord. She is seeking transfer of matrimonial suit, my lord, filed by her husband in Tinsukia, from Tinsukia to Dibrugarh, my lord. And already my two proceedings are pending at Dibrugarh, my lord, instituted by wife, my lord.
Just a minute. Petitioner is the second party.
My lord. No, petitioner is the wife, my lord.
Second party.
Second party, my lord.
Suit for divorce.
Suit for divorce
Where?
at Tinsukia, my lord.
Where do you want?
At Dibrugarh, my lord.
At Dibrugarh.
My lord, reason I am saying, my lord, there are two proceedings pending at Dibrugarh, my lord.
Dibrugarh in the state of Assam or some other state?
Huh.
How far is it Dibrugarh from Tinsukia? 45 minutes.
My lord.
Maybe for the court at Dibrugarh would be also 40 minutes from your place.
But my lord, already two proceedings are pending which is being contested by the husband, my lord. If one proceedings come to Dibrugarh, my lord, it will be more convenient for the husband because
What are the other proceedings?
one is DV Act, my lord.
DV Act is before a magistrate.
And the other is, my lord, regarding 498A, my lord.
498.
my lord.
Where? Before a magistrate.
My lord.
Not in the same court.
But my same district is same. If,
District
if
is
all
same.
my lord, if all cases are fixed on same date, then it can be convenient for the husband also, my lord. And my lord, lordship is
You need not think about the convenience of the husband. He will think.
because I am a
You
lady,
have
my
come
lord.
to this court thinking about the convenience of the husband.
My grounds are that, my lord, I am not financially sound, my lord. I am living with my ailment.
How far is the court at Dibrugarh from your place where you are staying now?
It will be around, my lord, 50 kilometers around. 50 kilometers per hour.
No, the court at Dibrugarh.
Dibrugarh, my lord. My lord,
The court at Dibrugarh, where you want to transfer now,
My lord.
how far is it from your residence?
it will be around 3-4 kilometers, 5 kilometers.
You have to, otherwise it's not in the neighborhood.
But my lord will see the end of the apex parties that my lord wife's convenience to be looked into, my lord. And when
Convenience, yes, for 45 minutes journey, what is the difficulty?
I'm relying on judgment of the apex court, my lord, if lordship may consider.
That is not one of the inconvenience which would come within those ambits. Had it from other districts, some Kamrup district or Dhubri district, matter would have been different.
Lordship,
Only for the sake of travel of 45 minutes.
but my lord will see from 2022, my lord, husband is contesting as to proceeding at Dibrugarh, my lord. Therefore, my lord, he will have, therefore, my lord, if it can transfer to Dibrugarh, my lord, it will not have any convenience, my lord.
You are lucky that husband has not prayed for transfer of the proceeding to Tinsukia.
Just, my lord, for, just I'm relying one judgment, my lord. If lordship allows,
We will issue notice, no stay.
but lordship will, then
No,
lordship,
sir.
my, one observation, my lord. I may be allowed to take justice service, my lord.
You take
And
this.
lordship will just observe that entry may be considered on our next returnable date, my lord.
Let us see. Heard Sri R.S. Mishra, Learned Counsel for the petitioner who has filed this petition under section 24 of the Code of Civil Procedure for transfer of transfer of title suit M number 1 of 2024 from the Court of the Learned Civil Judge. Civil Judge,
The junior division, my lord.
why? Matrimonial suit?
My lord, it is filed in this court only, my lord. At page 28, my lord.
Matrimonial suit, what was the jurisdiction?
It is, my lord. It is not filed under any specific, since the parties are covered by Muslim law, my lord, they have filed a declaration suit, my lord.
Oh, it's not under the Hindu Marriage Act.
No, my lord, it is under the, they are parties governed by Muslim law, my lord.
It's a declaratory suit.
Declared suit, my lord. Declared suit, my lord. Then, my lord,
For transfer filed Learned Civil Judge Junior Division Tinsukia to the appropriate court with jurisdiction in the district of Dibrugarh.
my lord.
Full stop. It is contended that the petitioner has in the meantime instituted
Ma'am. 2
proceedings against the respondent -1 under the Domestic Violence Act and the other
498A, my lord.
for
498A, 406. my lord.
and another under section 498A and other sections of the Indian Penal Code. Full stop. It is also contended that the second party husband, that the respondent husband is contesting those proceedings. Full stop. Para. Issue notice returnable on
Can it be, my lord, before vacation, my lord?
before vacation will be possible. Today is what? Today is 10th.
Because my there is date fixed on 11/7, my lord. And there is a vacation, my lord, here. If can it be 20, I will take justice service, my lord.
11/7 courts are
At this, my lord, at Tinsukia, my date is fixed on 11/7, my lord.
difficult. Last week it has not been possible. Fixed on returnable on 26th June. Let us see. Try 26th 6. Para. Let steps be taken for service of notice upon the opposite party, upon the respondent opposite party by registered post with AD. Full stop. The Learned Counsel also prays for allowing steps to be taken by Dusty Service. Full stop. Para. The aforesaid prayer is allowed and such steps by Dusty is to be routed through the registry of this court and in the notice accompanying the Dusty, the next date fixed, that is i.e. 26/6/2024 is to be clearly reflected, full stop. Prior to the next date, the petitioner is required to file an affidavit in proof of such Dusty service.
Only one observation, my lord. It may be considered on that day.
Para. the prayer for interim order may be considered on the returnable date. On the returnable date on appearance of the respondent.
Oblige, your lordship.
But caveat is. May I please, your lord. My lord,
Let us discharge the caveat. Heard. Three, D. Mazumdar Learned Senior Counsel. Assisted by
T.R. Datta.
Shri G.R. Datta, Learned Counsel for the caveator who had lodged this caveat in respect of a judgment and order dated, a judgment and decree dated 17/2/2024 passed by the learned civil judge, senior division number 2, Kachar, in title appeal number 12 of 2022, full stop para. The caveator would be heard in the event this court proposes to pass any interim order para. Caveat stands discharged. Yes.
My
Mr.
lord,
Ghosh.
this is the case of landlord and tenant, my lord.
Okay.
Here in this case, my lord, basically,
You are
I am the tenant.
tenant, defendant,
Defense,
sued for ejectment
rejectment,
and recovery.
recovered. And they have also prayed for declaration of right. But that point has been held that since it is a matter of landlord tenant, so need not required to go into that.
Hmm.
So I am also not on that.
Hmm.
I am basically on the two ground, bona fide requirement and defaulter.
Hmm.
And in the bona fide requirement and defaulter, both the court below held that I am the defaulter and bona fide requirement is since they have pleaded for bona fide requirement and in
Suit
this
was decreed.
suit was decreed,
Appellate court has
affirmed.
affirmed.
Now,
What are your grounds?
my ground is that regarding bona fide regarding defaulter part, the learned court below have not considered the evidence of exhibit E, by which all the rent receipt from 1996 onwards has been called for, and subsequently the
The exhibit is a petition.
exhibit E,
Is a petition.
yes,
Yes.
by which not one exhibit here,
Hmm.
exhibit E 1 to exhibit E from 1 to exhibit E it is 14,
Hmm.
1 to 14,
Exhibit E1 to E14
E4,
are rent receipts
certified copy of
of
the rent receipt,
you had deposited in NJKs.
NJK. But this from March 1993 to December 1995, that receipt we could not able to produce because we applied for certified copy
From?
from March 1995
Hmm.
to December 1995.
Hmm. Yes.
Because the document which I have sought for certified copy that has been destroyed due to time. So they did not supply the certified copy of that document, for which I could not able to produce the same. On the other hand, I have also filed application calling for documents, this rent document from the court below, but court below had rejected on the ground that I may produce the certified copy of the same.
Hmm. Hmm.
So I applied for certified copy, and those certified copy which have been provided.
Mr. Mazumdar, we'll have this for disposal.
Yes.
on a date, you,
It can be disposed today also. My landlord is saying that the rent receipts were called. First of all, at that time, he could have come here that it's a call, it's not. Other
today
than
is the
this,
first day.
Lordship may give him the next day, my lord.
My lord, a date may be fixed, my lord, by calling for the record, my lord. Record is also necessary.
We'll think if you,
Yes.
if we need the
Yes,
records.
yes.
My lord,
It's a
record is,
concurrent finding on a landlord
My lord,
tenant.
there was no offer. He deposited. Finding of the court will neither he says there was offer, and in cross he admits that I have not offered.
So straight away he deposited.
no, my lord, that respect, there is a perversity, my lord. And regarding,
So if, see, these are exclusive grounds, as
Yes.
you know.
Yes.
Bona fide and defaulter.
no,
should-
bona fide has not been proved.
Bona fide and defaulter are not required to be proved together. Any one of the grounds will be enough.
Any one of the.
Now, bona
Yes.
fide you said are not proved. If
Any-
defaulter, if you admit, if you fairly said it's perverse, but still then we'll have it for hearing.
Well,
yes.
Today, not
Well,
today.
After,
I'll leave it to you, Lord.
After the vacation, but we'll fix a date.
Yes.
Will not go on, go on
Yes,
with this. Tenancy of which year?
2006.
2000.
Eviction 18.
no, tenancy of, not
80.
89.
89. Have you taken some instructions? How long will you take to vacate?
I'll take it.
Take instructions.
And apart from that, my lord, during pendency of the case, I have been accommodated one shop room where they have constructed 100 shop in a market area,
100 shops.
100 shop. And one I have been accommodated,
You are against the government or what?
my
They are
lord.
the state government or what?
No, 100 shop room
100 shop one individual has constructed.
in a one market.
Which place?
Filter. Market, Hilora market.
100 shop rooms.
Yes. And one I have
don't know
been
whether I have
accommodated.
taken- But that.
Are you
have
submitting
lordship-
on instructions? Is it
Yes, yes.
100 rooms? Are you,
It is on record also.
have you just imagined the magnitude? 100 rooms.
Shop rooms, my lord, in a market, maybe
Shop rooms or whatever, one person will have to enter it.
100 shop room. And in backside, they are nursing home also.
Lordship will fix the date, my lord. Same
Okay,
court
okay.
time.
So I have accommodated only a small portion of,
You have been given a room.
yes, I'm running my business.
You're still running a business.
Yes,
So
yes.
what is your difficulty? Why don't you settle the matter?
Yes, that's my possible. By enhancing the rent also.
Oh, you have been evicted from that small
No,
room?
No, not.
This is a new accommodation.
During pendency, I have been newly accommodated here.
Okay. Oh, so you are not homeless
Not
or
homeless.
shopless?
No, not shopless.
Okay. Heard Sri S.K. Ghosh, learned counsel for the petitioner who has challenged the judgment and decree dated. It is caveat the lekhisilu, setu. So and so passed by full stop by the said judgment, comma, the judgment and decree dated 30/3/2023 passed by the learned Munsif number 1, Kachar,
22.
in TS number 470 of 2006 has been affirmed. Full stop. The suit was for ejectment of the petitioner who was a tenant and for recovery of area rent. Full stop. Para. It is submitted that two grounds were formulated for instituting the suit, comma, the grounds regarding bona fide requirement was not proved, and the ejectment has been done on the basis of defaulter, full stop. It is submitted that there was no default in payment of rent, full stop. Para. Sri Mazumdar, the learned senior counsel for the respondent, has however submitted that the findings arrived at by both the learned codes below are based on materials on record and upon a proper appreciation of the law concerning landlord tenant. Full stop, para. Let notice be issued, returnable on
16th July.
Returnable on 23rd of July. 23rd of July. Sri Dr. Learned Counsel, assisting the senior counsel for the respondent, accepts notice on behalf of the sole respondents, on
There
the,
are
on
two-
behalf of
Two
the,
respondents, two
of
minor.
the respondents, of all the respondents. Para, respondents. Para, considering the subject matter of dispute and also the fact that the impugned judgment is of affirmation of the original judgment and decree, an endeavor would be made to dispose of this, to take up this matter for final disposal on the next date fixed.
My lord, in the.
Have you gone for execution?
My lord.
Well, I'll tell you not to start it.
No, no, no,
Take it.
okay, okay,
I
okay.
assure.
That may be.
I will record,
reflected.
Sri Mazumdar, the learned senior counsel for the respondent has submitted that he would instruct his clients not to initiate any execution proceedings in the meantime.
Yeah.
My lord, in 2022, not 23. Entitled to 22.
Period 23, title appeal is of 2022,
No,
which date?
33, 2022. 20. One second.
33, 2022.
Two.
Oh, the judgment has written, is written 2023 in the certified copy.
That's a good. In the rec. I have submitted certificate.
You take the,
2022.
no, no. You take the impugned judgment, come to the second page. Impugned judgment of the appellate court.
Appellate court. There is
Come-
a.
Come to the second page, page number 2,
Yes, it is wrongly.
23.
22.
Paragraph 1, it should be 22. 22.
Impugned judgment.
All right.
One.
Item 4.
Me, please, your lordship.
Yes.
Lordship, this revision petition we have filed against the order dated 9/1/2024 passed by the additional session court Dibrugarh, framing charges against us under the Land Grabbing Act. So, your lordship, the facts are that we have been continuous possession of a land measuring 14 bigha 10 lecta.
Petitioner is what? Oh, the opposite party
Opposite party.
in a
the
land grabbing act,
grabbing act.
in land grabbing proceeding.
Yes.
Yes.
So we are in continuous possession of a land measuring 14 bigha 10 lecta.
14 bigha 10
10
lectures.
lecta, yes. Under Assam Temporary Settled Areas and Temporary Settled Areas Act 1971. Under the it was a T patta land.
No, you have mentioned this act where any in non-evictable right conferred upon you under section 23.
Pardon,
You have just mentioned the act of 1971.
1971.
Was any right conferred upon you under the act under
mm,
section 23?
no, your
You just don't mention an act then. If you invoke the act, something has to be done under the act and some right has to be conferred upon you. You are saying that you are
we are the Khatiyandar under
Khattiyan,
yes.
but was any, did you institute any proceeding under section 23 of the Act of 71?
No.
then how do you become a non-evictable tenant? Okay, doesn't matter.
But we are never evicted.
You are a
uh,
Khatian holder.
We are still the Khatian holder. We are paying the land revenue. It was initially in the name of my father, and now after his death, it has devolved onto us. So, Your Lordship, after that, on January 2011, the respondent has occupied
2011.
2011. This land we have taken possession in the year 1977, and in the year 2011, the respondent in the present petition, he has erected a temporary shed there to carry on some liquor business.
The present respondent.
The present respondent, yes.
Yes, they had what?
And thereafter, he destroyed some tea bushes also. We are doing tea cultivation in that area. So, as a result of that, we filed a title suit for recovery of past possession and permanent injunction in the year 2011, which was withdrawn by us in the year 2014 due to some formal defect in that suit.
Yes.
And again on 11/7/2017, we have lodged a FIR on the respondent again on the ground of uprooting about 50 number of.
You did not institute a fresh suit.
No, till now
Why?
we have not instituted a fresh suit. We filed a FIR on the allegation that he has uprooted 50 tea bushes and also destroyed some goat fencing. So, he was arrested due to that FIR, and later when he came, he found that except his shop, the rest of the area was separated by erecting boundary wall, as has been alleged by respondent. So therefore, he has instituted this land grabbing case for illegal grabbing and for demolition of those boundary walls. Now, our contention is that we are in continuous possession, and that regarding we never erected boundary wall also. We have only repaired those 50 uprooted bushes, and we have repaired
But
them.
only charges have been framed.
Only charges have been framed,
What is the
but there
present-
is no criminal intention as such. This is purely the nature of the case is purely civil. So these charges could not have been framed under land grabbing, because
Is there a provision for paying for discharge at the time of framing charges in like in a normal criminal case?
that is not
Did
there.
you exercise that option?
No, that I'll have to take instructions.
You
whether-
take instructions. If you had prayed that ingredients are not enough to frame charges, in spite of that, the order has been passed, then perhaps it can be matters of examination. But you have not availed the remedy. You seek instructions, okay? When is the next date?
Next date also I'll have to.
Take instruction. We'll have it on, before the vacation, we'll have it. Today is what? Today is 10th. We can have it on 21st. Is it okay? On the request of Sri S. Dr. Learned Counsel for the petitioner, matter is adjourned to be listed on 21st of June 2024 to enable him to obtain instructions. Okay.
Obliged.
I think 54, something is.
None appears for the appellant on call. Para. On the earlier occasion also, that is 6/6/2024, none had appeared for the appellant when the matter was called, and accordingly, this court had made an observation that in case of further non-appearance, comma, appropriate orders would be passed. Full stop. Para. No, full stop. Para, no. This court had also observed that the suit is of the year 1997 and the second appeal is of the year 2008 and is remain pending for the last about 16 years. Full stop para. The appeal accordingly is dismissed for non-prosecution.
Item 5.
Met with the
Instructions,
No, allow this.
huh?
Allow this.
Allow.
We have to speak in any.
Have you taken, are you making the submission on instructions or from your own?
I have not received any instruction, but I repeatedly tried to call him, inform him to withdraw the petition. I communicate the Honorable High Court order, but he did not.
The PV case is also going on at Tinsukia. In that case, he was directed to pay interim maintenance. That is not also not paid for last 6 months.
Okay, this is a transfer petition.
Yes, sir.
You are what?
I'm for the wife.
Petitioner is the wife.
Wife,
Wife means the first party or a second party.
second part.
And the proceeding is for
Proceeding is for divorce.
by the husband.
Yes, sir.
Suit for divorce.
Just for dissolution of marriage. Title suit number TSM.
That is okay. We'll get. What are your grounds? Where has it been at instituted at Sibsagar?
Transfer from Sibsagar to Tinsukia.
No, it is instituted at Sibsagar.
Yes,
At District Judge Sibsagar.
yes.
You are praying for transfer to?
From Sibsagar to Tinsukia.
Grounds?
No income. No one accompanied to her to travel to Sibsagar. And it is child of 2 years, 10 months. At the time of filing the petition, 1 year, 7 months.
A child, son, daughter,
Child was son,
son of 2 years.
2 years.
And heard?
No one to accompany her to Sibsagar. And another ground is that a TV proceeding is going on at Tinsukia and he is contesting that case. That number is Miss Case Domestic 20/2023.
Okay, what is the distance?
Distance is around 125 kilometers.
Is it 125?
Around,
I think less.
I have to say. $118.5.
Okay. Since you are not contesting, so. Heard Sri S. Jaka, Learned Counsel. Please have your seat. For the petitioner who has filed this petition under section 24. Read with section 151 of the Code of Civil Procedure. Praying for transfer of title suit within bracket matrimonial number 118 of 2022 from the Learned court of the district judge, Sivsagar, to the appropriate court in the district of Tinsukia. Tinsukia, there is a family court, no?
No, district.
Para. The learned counsel has submitted that the said proceeding is for dissolution of the marriage instituted by the second party husband. Full stop. It is submitted that the petitioner does not have any income of her own and has a son of about 2 years. Full stop. It is also contended that there is none to accompany the petitioner from Tinsukia to Sivsagar, which is about 120 kilometers away. Full stop. Finally, it is submitted that the petitioner has already instituted a proceeding under the Domestic Violence Act at Tinsukia. Who is contesting or not?
Yes, it's contested.
Which the respondent is contesting. Full stop. Para. Ms. R. Begum, learned counsel for the respondent, has however submitted that in spite of her best efforts, no instructions could be received, and therefore she is not in a position. No instruction has been received. Full stop. Para. Sri, however, opposes the prayer for transfer. Full stop. Para. It is not in dispute that the learned district judge Tinsukia would have jurisdiction to try the suit. Full stop. The grounds cited in support of the transfer, namely the petitioner having a minor son of about 2 years and the factor of distance from Tinsukia to Sivsagar is also a relevant consideration. Full stop. Para. Under the aforesaid circumstances, the instant petition is allowed and the aforesaid title suit matrimonial so and so pending in the court of the learned district judge Sivsagar is accordingly transferred to the court of the learned district judge Tinsukia. Full stop. The interim order accordingly stands merged with the final order. Full stop. The parties who are represented in this court are accordingly directed to appear before the learned district judge, Tinsukia, on 27th of
27 is holiday, Lord.
June.
June is
June 27th.
June is
You get certified copy today itself on 27th of June, along with a certified copy of this order, whereafter the learned district judge, Tinsukia, will take charge of the proceedings and proceed in accordance with law. Full stop. In the meantime, the records of the case are to be transferred from the court of the learned district judge Sivsagar to the court of the learned district judge Tinsukia.
Item 6.
disposed of. Huh?
My place of it. My lord, service is complete, my lord. Flag A and flag.
Wait, please, my lord. But on the claimant, my lord. But in this case, my lord, 50% amount may be deposit. Matter may be admitted. Mention my lord, 50% amount may be deposited.
Here for the claimant.
Claimant.
It's for admission.
Already admitted, my lord. We are admitted and state granted. 5 and 6 and 7 are the analogous cases. 45 my lord. And we also
This is for WC.
WC.
Okay. It has already been admitted.
My lord,
Admitted on 31
Yes.
2024.
on that matter was admitted, my lord. On this date, my lord, notice was issued, my lord. On that day, my lord, we are not appear. Letter on appear, my lord. When the matter was admitted, my lord, that time it was not.
Not necessary.
Then, my lord, kindly, my lord, 50% amount.
Well, already given the order staying the matter, giving the amount of, in this case particular, 1,50,000 possible. And
Mention number 4.
there is a my lord, dispute regarding the amount awarded by the landed commission.
Where is the IA? IA has been
IA
disposed of.
Yes, giving the direction of to deposit the amount, my lord, it is there, man.
It is already there.
Let them to file a my lord,
I
petition.
don't ever about the IM, my lord.
You have to go through the record.
There's an order of 31 2024. Remain staged till disposal of the appeal subject to deposit of 1,50,000
Yes.
of the awarded amount in the registry of this court.
Yes.
I think,
File a
You get,
yes,
is there any other,
my lord,
Respondent.
record has not called for record, but till today not received.
and how many respondents are there?
My lord, 2 respondents are appeared.
Both
one
have
is
appeared.
Service is complete.
Okay. The learned counsel for both the respondents have appeared through the learned counsel. Full stop. It, para. Though records were called for. Wide order dated 31
One,
2024, comma. Office note depicts that the said records are yet to be received. Full stop. Office to issue requisition. Office to issue reminder for the records. List after receipt of the records.
6 to 7 of the same, analogous case.
6 kilometers, same matter, my lord.
So you're
Same
appealing.
My lord, order may be passed in a take together, my
7, same order.
Only.
List, last October list along with MFA, 4 of 2024.
Well.
Same accident,
same activity.
For hearing, my lord. Yes.
not for
Let it-
hearing. The records will have to
Yes,
come.
yes.
Matter.
May I please, your lordship. My lord, this is the second appeal, my lord. It has concurrent finding. But basically, case is suit filed under the TP Act, my lord. For eviction, declaration, and recovery of possession. But when this suit was filed, my lord, the notice under the TP Act, because they are claiming that we are the tenant, and since we have not paid any rent, so we are entitled for eviction.
Just a minute. You are the appellant is the what? Defendant.
Dependent.
Suit for
Suit for declaration of right title interest and possession.
recovery of possession or
Yeah,
confirmation.
Recovery of possession.
Yes. Suit was
Suit was decreed.
decreed. Yes, thereafter,
Then appeal
appeal dismissed.
dismissed.
Yes, what had happened?
They have filed this suit on the ground that we are the tenant,
Appellants are the tenant. Hmm.
and we are liable to be evicted because they have acquired right title interest on the basis of purchase deed in the year 1981.
You are the tenants of the original vendor.
They, as per them, as per their statement, we are the tenant of this plaintiff,
Not the original vendor.
not the original vendor.
Okay. Are the tenants, the purchase was when?
81.
By registered sale deed?
By registered sale deed. On
By,
pa-
by the plaintiffs
by the plaintiff,
of the suit property?
predecessor of the plaintiff,
Of the suit property?
of the suit property.
Yes.
By the predecessor of the plaintiff.
Okay. Now,
Now,
when were you inducted as tenants?
my lord,
As per them,
as per them,
when were you inducted as tenants?
as tenant, yes. As per them, 2005.
2005, you came as tenants. Okay.
Kindly see page 9, my lord.
Okay. Thereafter?
Then their claim is that I am defaulter, so I may be evicted, and a declaration is to be given in their favor for declaration of right title interest.
Why declaration?
Basically, we have challenged that actually this suit land was purchased by the brother of the defendant, who is the own brother, who has purchased in the year 1981
Your projection.
in my possession.
No,
Well,
your projection.
not projection. It is the admitted fact.
Admitted fact, who purchased?
My
Why?
defendant's brother. Vishwajit Dev,
Brother, okay.
own brother of Robindra Kumar Dev.
You are Rabindra Kumar.
No, I am for Vishwajit Dev. I am Vishwajit Dev.
Your brother is Rabindra Kumar.
Yes,
He purchased
he purchased.
Rabindra. Okay, then?
And when it was purchased, and prior to that, we are in possession of this suit land. They never got the possession over the suit land. And apart from that, on a condition that
Vishwajit is the opposite
Own
party
brother.
here.
is the
Okay.
respondent.
But you are in possession, you say.
Yes.
Your position, you're in position on the strength of what?
We are in possession because my predecessor were in possession, and on the basis
Predecessor
of
will be his predecessor also.
same predecessor.
Okay.
Yes, same predecessor. But property was sale was made in the year 1981.
No, but Vishwajit, Rabindra purchased from whom?
Robindra purchased from the original owner.
Name?
Name.
And you were, the entire family were tenants of the original owner.
And not entire family. We were.
Two brothers. Now you say that when the property was purchased by Rabindra,
Yes,
you were already in possession.
we are in possession.
That means at the time of purchase, you were in possession.
I am in possession.
Rabindra was also in possession.
No, they are in Silchar. They are in different places.
And this property where?
Property is in Hailagandi.
Is the sale subject matter of any counterclaim? No.
Regarding no contract.
You did not challenge the sale.
No, I did not.
So title was transferred to him
Title
by the original
Yes.
Now, what is the basis of your position?
Possession, my lord, my basic case is that when they have filed a suit under the TP Act, my lord, and they are themselves claim that I am the tenant of the plaintiff. I am the tenant of the plaintiff. So notice under section TP Act,
103.
it is because after termination of lease agreement, notice is required. That part is not given in this case. Kindly see the plaintiff, my lord, whether notice has been given or not. One paragraph I will read out, my lord. Paragraph 6, page 11. Duration of certain lease in absence of written contract or local interest. 106. Because this suit property is in Panchayat area, my lord.
It is not in urban, it is not under the urban areas.
Not
land
urban,
control right.
urban areas. Ma'am.
Yes, Mr. Broadcaster.
My lord, case was, my lord, to be, my lord, honest enough, my lord, case was projected in different. My lord, there are whole cases that land was purchased by me. Me means my father, Rabindra Kumar Dev. And Rabindra Kumar Dev was a very kind person. And having their helpless condition, Rabindra Kumar Dev allowed them to stay in the house. That is their whole case. And both the courts arrived at the conclusion that he is nothing but a permissive occupier. Although we took a stand initially that he is a tenant, but that was rejected by both the courts. Issue number 4 was decided in negative, whereas issue number 3 was decided in our favor, saying that, my lord, he is a permissive occupant. And once he is a permissive occupant, there is no any question to my lord, raise any objection against the title of the, my lord, owner. That was the concurrent findings of both the court. On the other hand, my lord, if I am not wrong to understand, section 106 doesn't have any application. Section 106 of TP Act relates to commercial or agriculture. So it is neither land was neither, my lord, letter to them for any commercial purpose or for agricultural purpose. Therefore, section 106 may not have any application, if I am not wrong to understand. That apart, my lord, once there is a concurrent finding, and holding the particular question whether he is a tenant, that was not decided in our
Mr.
favor.
Broadcaster 106, please read 106.
My-
There are two components.
My-
One is agriculture, one is immovable property. Immovable has not been qualified to be commercial property.
106. In absence of contract or local law for assist the country, a lease of immovable property for agriculture or manufacturing purpose.
Yes, please read ahead.
Yes. Manufacturing
Shall be
purpose
deemed to
shall
be a
be
lease from year
deemed
to
to be
year,
leased
terminable.
from year to year, terminable on the part of either lessor or lessee by 6 months notice. And a lease
And a
of
lease for immovable property for
Immovable.
any other purpose shall be the lease from month to
property
month.
for any other purpose shall be deemed to be leased. And the lease of immovable property for any other purpose. Even then, my lord, that plea was not accepted by the court.
No, that was your plea.
No, court, that is the findings of the court.
No, you had said
My
that
lord.
he is a tenant
My lord,
and you wanted eviction of him
my lord,
by invoking TPA.
my lord,
Now, if you invoke TPA,
my lord.
106 would come.
My lord,
Where is the decision, Dhanpal Chettiar? Have you got Dhanpal Chettiar?
That I have not brought.
Why?
Mm.
You should get at least Dhanpal
Yeah,
Chettiar.
Dhanpal Chettiar.
There's M Dhanpal Chettiar or what? There's another prefix M or N. M Dhanpal Chettiar.
M Dhanpal. लिखा तुम नहीं क्या इतना ही याद है मतलब M Dhanpal Chettiar. Look, on the other hand, if their submission is recorded that there is no landlord-tenant relationship, then section 65 of the Limitation Act will come.
cannot question. Occupant, my lord, permissive occupant cannot question the
No, no,
title,
permissible occupant under what condition?
because he was allowed to.
Is there any evidence that you permitted him?
Yes, yes, not that.
And he was occupying not
Yes, yes.
in hostile
Yes, yes,
assertion of his rights.
yes, yes.
That I have pleaded.
You have pleaded?
Yes.
They pleaded them, they were allowed,
Then section 65.
No. Is
I-
the Mr. Purkastha,
my lord,
please respond to the question.
My lord.
In his written statement,
my lord.
the projection was that he was in adverse position or he was in permissive.
No, he was in permissive position.
No, his
you-
his contention.
His content.
Let us see DWS.
Yes.
And Mr.
My contention, my lord.
Yes, let us see your contention.
The real fact, page 20, my lord.
20. Yes. Please
Yeah.
show us that part.
Uh, That the defendant number 1 is the youngest brother of Ravindra Dev, who was.
I don't think that is a pleaded case. And see, your brothers, adverse position will be very difficult on your burden will be very heavy upon you. There is an assumption of permissive possession.
But we have constructed.
Where is the pleadings that you had?
Constructed.
No, not construction. That you were occupying in open assertion of your rights.
That is there, my lord.
Where?
I'm saying.
We don't find. Rather, in page 21, internal page 7, you said sympathetic consideration you were allowed to stay.
Yes,
My lord, page 25 can you see? High,
25.
high. Yes.
Yes, which one?
Paragraph I, that defendant number 1, 2 are the owner of the holding and building was constructed by defendant number 1 and defendant have been residing there for more than 34 years, which is beyond the period of limitation.
No, 34 years limitation will
Was
come
not a
when?
tenant, was not a tenant over the stood building and defendant were not all along evictable as per provision and so Rent Control Act or Tenancy Act or any other law for time being in force by continuous possession of defendant over
Mr.
the
Ghosh,
stood land.
this ground may not be available to you. We do not know at this time. But 106, perhaps you are able to make out a ground.
Yes.
Where are your substantial questions?
Substantial question of law, my lord, at page 6, my lord. Page 6.
What is the stage of the execution?
Not, we are in possession.
Executed.
No.
Execution started.
No.
Not even initiated.
No.
Okay. Mr. Purkastha will admit this on the first question.
Mal.
Okay. Heard Sri S.K. Ghosh, learned counsel for the appellant, who has preferred the second appeal under section 100 of the Code of Civil Procedure against judgment and decree dated so-and-so appeal, affirming so-and-so, at a cost title body river. It is submitted that the suit itself had projected the present appellant defendant as tenants.
Tenant.
And the area in question is under the, it's not under the urban areas,
Not under.
is outside the purview of the Urban Areas Rent Control Act. Full stop. The clear case of the, amongst others, comma, it is contended that there is violation of the provisions of section 106 of the Transfer of Property Act 1882, as there was no notice issued at any point of time. Full stop, para. The appeal is admitted on the following substantial question of law. Page 6, number A, able and diva, single, number and diva. Any other questions? That's what it is, diva. Let's steps. You are accepting for all. 3 AK Purcast, Learned Council accepts notice on behalf of all the respondents. Let extra copies of the memo of appeal along with all enclosures be
Yeah.
served upon,
We have already.
be served upon him. Full stop. Upward LCR call for to us, list after 6 weeks along with report on the records, on a report on receipt of the records. Yes.
And there is an IMI.
I for
Same.
heard. 3 SK Ghosh Learned Counsel for the applicant appellant, who by means of this application filed under Order 41 Rule 5 of the Code of Civil Procedure has paid for stay. Full stop. Para. The connected appeal RSA 146 of 2023 against Gutekin Lihiba has been admitted today. IE date 2. Para. Considering the above, also heard Sri AK Purcast, Learned Counsel for the respondents, who has however informed that till now no execution proceeding has been initiated. Full stop. Para. Be that as it may, comma, till the disposal of the connected RSA 146 of 2023, comma, the impugned judgment and decree dated so-and-so of the so-and-so shall remain suspended. I stand disposed of. Item 9. Yes, what is this?
May I please, your lordship. The appellant before your lordship is the plaintiff, your lord. The appellant filed a suit, your lordship. Suit for declaration, eviction, permanent injunction.
Just
and
a minute, just a minute. Item number. Appellant is the plaintiff. Suit for
plaintiff. Suit for declaration, eviction, permanent injunction and consequential relief.
okay. Yes, what had happened?
Lordship, the case of the appellant plaintiff is that she got the suit property through oral gift. Is
Oral gift?
yes, my mother-in-law.
Mohammedan, okay.
Yes, Lord. And from whom she from whom she got the suit land. That particular person got the suit land by a registered gift deed, your lord.
Vendor got by registered. deed.
Vendor was the Tony was the registered gift deed, donor. Got the state property. Through municipal board, your lord. Municipal board. That is the question, your lord.
Municipal board registration.
Yes, your lordship. I'll show your lordship. And
Property is where?
property, Shivsagar district, your lord.
No, where? In the town.
Town, near the municipal, within the municipal board, your lord. Lordship, kindly, see.
There is no registration office.
No, lordship, the municipal board registered the gift deed in favor of the donor of the plaintiff.
What is this kind of registration?
That was in the name of a municipal board property, your lord. Municipal board property, municipal board through a registered gift deed. Now,
So
Lord,
the board was the donee
donor,
for your vendor, for your donee.
yes, dear Lord. Donor for my donor.
The municipal board can gift its own properties.
That is the question to be decided.
Who had
your Lord.
executed?
Lordship,
Who had executed? The-
chairman. The registered deed was exhibited, that was not challenged, your lordship. Lordship, kindly see page 15, your lordship. Page 15, the WS of the respondent defendant, your lordship.
Why are you instituting this RSA? What will you get ultimately? What is your substantial question? Any substantial?
Substantial question of lordship, the issue number 3, lordship, kindly see page 48, your lordship.
What are the substantial question? Let us see.
My substantial question of law, lordship. Page 7, your lordship. Whether the findings of the learned courts below are perverse in nature, 2, your lordship. Whether the findings of the learned courts below in regard to the title of the Shivsagar Municipal Board, predecessor of the appellant plaintiff, is sustainable in evidence on record. Lordship, the court below examined the lot mandal of that area, your lordship. I'll have a copy.
No, the basic question which will arise is whether the municipal board had the jurisdiction to execute any gift deed.
It is in the name of municipal board, the property, yes, lordship. That was admitted in their written statement, your lordship.
The chairman takes a decision to gift a part of the property.
That was not challenged, your lordship. Neither municipal board nor claimed, your lordship. That in their written statement, your lordship, they have specifically admitted, your lordship. In the written statement, may I read, your lordship? On the basis of evidence of this DW7, both the courts below decided that the municipal board did not have the title over the state property. Here, your lordship, kindly see সরকারি ডাক নাম্বার শিবসাগর টাউন পার্ট 2 চকবাজার নামে সংরক্ষিত সরকারি জমি, তার মোট মাটি আছে 5 বিঘা 1 কঠা 6 লুসা। দ্বিতীয়, ইন ট্রেড সাইটৰ মাটি 5 বিঘা 2 কঠা 6 লুসা। ক্ৰছ ইউৰ লৰ্ডশ্বিপ, মই ইতিমধ্যে ইন চিফ এভিডেন্সত মৌখিকভাৱে কোৱা কথাখিনিৰ ছাপোৰ্টত কোনো ৰিলেভেণ্ট চৰকাৰী কাগজ দি প্ৰমাণ কৰা নাই।
সত্য নহয় যে
সত্য নহয় যে ইন চিফ এভিডেন্সত কোৱা কথাখিনিৰ এই গোচৰটোৰ লগত কোনো কানেকশ্যন নাই। That DW7 only adduced evidence without supporting any document that particular property is government land, your lord.
So, but there was an evidence, it's a government land.
Only this oral evidence, Your Lordship,
Mr.
without any
Lakman, he has not produced any document.
Lordship.
He has said that he has not produced any document, but he is
In
clear.
regard to the, and Suitland is only Lordship,
Let us see the findings.
two kata one Lordship, findings and Lordship, issue number 3,
Page,
issues start from page 47, Your Lordship. And 48, issue number 3.
48.
Whether the plaintiff has acquired any right, title, and interest over the suit property by virtue of oral gift made by late Jusna Begum in her favor on 22/4/2011. That was discussed in page 49, issue number 3 and 4 together discussed. Paragraph 8, Your Lordship, issue number 3 and 4. For better appreciation of the fact of the suit, I deem it fit to discuss the third as well as the fourth issues together for consideration, where it is seen that in order to prove the contention mentioned in the plaintiff has adduced four witnesses from her side, coupled with by adducing the documentary evidence such as the death certificate of Jusna Begum as Exhibit 1 and a certified copy of registered gift deed dated 5/6/2014. It is made by Municipal Board in favor of Jusna Begum as Exhibit 2 and certified copy of criminal proceedings instituted against the defendant as Exhibit 3, so corroborate her contention. Lordship, this escape kindly.
What is exhibit core?
Exhibit core witnesses from their side along with official witness coupled with existing documentary evidence, certified copy of Ticha of Dag number 1166. Exhibit 4.
That was exhibited.
Yes, that was exhibit.
So even if the Latmandal had not come with the official records,
And in the Lordship, kindly see that observation, Lordship. Page 53, your Lordship.
yes, we are at page 56.
56. Your Lordship.
Yes, paragraph 23.
Page 50.
6.
Kindly, Lordship, page 54, from page 54.
We have read 54.
Yes. Paragraph 19. DW7, namely Syed Ryan Momin, who worked as a lot mandal at Tipsagar Navamal Moja, and who is adduced as a court witness at the insistence.
We have read this. You have,
Yeah,
you have in
yes,
fact
Lordship.
shown this.
Now,
Chapter
Lordship,
7.
now,
What
Lordship,
about the core? Exhibit core at 23.
page 23, your Lordship, page 23. However, that
Yes.
brings us the appraisal of penultimate matter as to the competency of Jusna Begum to transfer the suit land in favor of the plaintiff, since from the evidence adduced by DW. From the version of DW7, it appeared that the land covered by Dag number 1166 is a government land, and the same is corroborated by perusal of Exhibit 4 submitted by the defendant side during their evidence in this suit.
Yes.
Lordship, kindly see now their WS page 15, your Lordship. Page 15, paragraph 6, your Lordship. That against the amendment made out in para of 2 of the plain, these answering defendants beg to state that Tipsagar Municipal Board had no right or status to donate the suit property to late Jusna Begum, in as much as the land in question over which the suit property is standing upon belonging to Gov, and the same is simply allotted in the name of Sibsagar Municipal Board. And under such circumstances, the government of Assam can only transfer the suit property. That was allotted in the name of Sibsagar Municipal Board.
It is an allotment. It doesn't become the owner. This is otherwise be atrocious. A municipal board donating its land without consideration. What is this?
And that was Lordship.
The chairman was not proceeded against criminally.
No, nothing was done, Your Lordship. The registered give deed, Lordship. It is
No, we are not on the registered gift deed. We are on the competency of to donate land. By the
because Lordship, it was in the name of municipal.
Can it be done? Just imagine a public authority donating land. Under what provision?
Lordship, that particular deed was not challenged, Lordship.
But the court has, both the courts have gone into. So far as your donee giving to you, there is no problem.
Yeah,
We have read this. And,
yes.
I think we are.
That was affirmed.
We are.
Only point is this, that whether my honor had the title.
Heard. Sorry. A.R. Shom, learned counsel for the appellant, who by means of this appeal, second appeal, referred under section 100 of the Code of Civil Procedure 1908, has assailed the impugned judgment and decree dated 7/3/2019, passed by the learned civil judge Sibsagar, dismissing title appeal number 7 of 2018 and affirming the judgment and decree dated so court title se dekh lijiye, so passed by the learned Munsif number 1 Sibsagar. Full stop. The appellant was the plaintiff in the aforesaid suit, which was filed for declaration, eviction, and for permanent injunction. Full stop. Para. The case projected in the suit is that the appellant had got the title of the suit property by means of an oral gift from one Rukhsana Jyotsna Begum. Full stop. Full stop. Now, who on the other hand had got the title transferred upon her by a registered gift deed by the Sibsagar Municipal Board. Full stop. It is submitted that the plaintiff, being Mohammedan, oral gift is permissible, and the said transaction was duly proved in the court. Full stop. The suit, however, has been dismissed and was affirmed by the first appellate court on the ground that the donee of the appellant plaintiff was transferred with the title of the aforesaid suit land by a registered gift deed by the municipal board, which was against any authority or jurisdiction, as the land in question was government land. Full stop. Para. The learned counsel for the appellant has submitted that though the Lat Mandal
Lord,
had adduced evidence as DW7 and had deposed that the land in question was government land, was protected government land, protected government land, comma. In his cross-examination, he had, however, admitted that he did not get the relevant document in that regard. Full stop. The learned counsel accordingly submits that the findings in this regard by both the learned courts below is not based on materials on record, and therefore the appeal is required to be considered on merits. Full stop. Para. This court has, however, on perusal of the issues, has found that issue number 3 was particularly on the aforesaid aspect, which is extracted here and below, page 48. 3, huh? Yeah. Issue number 3. 3 he linked in, huh? Para. The said issue, along with the issue number 4 regarding entitlement to a decree, has been discussed in elaborate details by both the learned courts below. Full stop. In fact, the learned appellate court, after discussing the evidence of the 4 numbers of plaintiff witness and 7 numbers of defendant witness, while coming to a conclusion that though the gift to the plaintiff by the said Jusna Begum was not found fault with, comma, the transfer of title by the municipal board to the donee of the plaintiff, namely Jusna Begum, was held to be without any jurisdiction. Full stop. Though reference has been made by the learned counsel by producing the evidence of DW7, the Lat Mandal, on lack of any document, comma, there is a clear finding regarding the concerned document being exhibit K, that the land measuring, that the land covered by DAG number 1166 is a government land. Full stop. The observation has also been made that, it also appears that the said government land was allotted to the municipality to run its operation, and by that, comma, by no stretch of imagination, comma, the municipality would have the authority to gift any immovable property. Full stop. Para. This court is of the considered opinion that, not to talk about any substantial question of law, comma, no apparent fault can be attributed to either of the judgments of the learned court below. Full stop. The appeal accordingly stands dismissed. Yes.
Lordship, India give there was a consideration amount.
Gift, consideration.
Yes, Lordship. Oblige, Lordship. Lord, here, 11 is already admitted, my lord. And this item, arrested 12, my lord. So this substantial question of law is at page number 69. Sixty-nine is whether the decision of the issue number 10 and 11 of the law.
RSA 4 of 2024 has already been admitted.
Yes.
We'll
Yes, my
admit, we'll admit this then.
My lord.
Admit this and
My lord.
what the formulation of the substantial question of law?
Yes.
Don't you think that it's very cryptic? Where are the
Yes.
decisions on decision number,
Yes.
issue number so and so are
My lord, actually,
pervasive?
perverse, sir.
Basic.
Perversive, no, it is not to have been perverse, my lord.
Otherwise, let us assume it is perverse. It's a typographical mistake. But don't you think that's a very broad kind of a question?
No, my lord, thing is that exhibit co and co was two bits, my lord, bit of agreement. The learned trial court held that exhibit co is and co are inadmissible in evidence because of these are unregistered documents. And the exhibit co does not bear the description of the property. Now, the appellate court held that both the documents have not bear any description of property for which it is
Not admissible.
yes, it was rejected.
And I tell you, issue numbers 1, 2, and 5 are relating to those two documents.
No, those issues are not relevant here, my lord. Only this 10 and 11 on the basis of this 10 and 11.
No, in RSA 4 of 2024, the substantial question of law which has been framed is with regard to the issue numbers 1, 2, and 5.
Yes, ma'am.
Are those issues the relevant issues?
In RSF 4, my lord.
Yes, 4 of 2024. It is the same judgment, isn't
Fine.
it?
Same judgment. The
The exhibits which you have just referred to, are those exhibits connected to issue numbers 1, 2, and 5?
No, my lord.
it is counterclaim part, my lord. This RSA 12 is counterclaim part, my lord.
And 4?
And this 4 is right as an interest, my lord. That has already been dismissed. That was decreed, my lord, by the learned trial court, and it is affirmed, my lord.
You are this present appeal which you are now
It is
considering
counterclaim, my lord.
counterclaim. Both
Counter-
the issues may be different.
Yes, my lord. Only this part is that whether I am entitled for the specific performance of contract or not. That is.
Let us see what are your. Where are your substantial questions?
It is, my lord, at
Page-
page number 69, my lord,
69.
69. Issue number 10 and 11, my lord, only. The 10 is that I am entitled for specific performance of contract, and that was decided against me, my lord. And 11 is for entitled for decree
Yes,
order.
in your draft issues, what have you written? Page 69.
69 is, my lord, whether the decision of issue number 10 and 11 of the learned first appellate court below, as well as the trial court, is perverse, my lord.
What have you written? What is the last word?
The last word is perverse, my lord. It is actually it would have been a perverse, my lord. I'm sorry, my lord. It's wrongly put.
See, framing an issue is very easy, but
Right.
ultimately while deciding the issue,
Right.
it will not be an easy task. We should frame the issue after understanding the facts. Only
Right.
because you have put a draft, we frame the issues. We cannot do such a mechanical exercise. You have to tell the facts, then only we can appreciate the issue or frame the substantial question of law. Appellant is the defendant.
Yes.
Yes.
Suit for
So for, my lord, plaintiff filed a suit for right title and interest
declaration of right title and interest.
and recovery of possession.
Recovery of possession.
And the defendant,
You are the defendant.
I am the defendant, my lord.
Defendant filed counterclaim
I filed a counterclaim
for
for specific performance of contract, my lord. And my plea was that that the suitland was given to me on the basis of two agreements, my lord. And on the basis of two agreements, he promised to sell the suitland to me, and subsequently he denied. Now, the plaintiff has not denied that he was agreed to sell the suitland to me. But his plea is that he resigned the, I resigned the agreement. So agreement is admitted. The plaintiff took plea that I resigned the agreement.
you had rescinded the agreement, the defendant, that was proved.
Not proved, my lord. No issue was framed on that basis, my lord, whether I resigned the agreement or not. That was not proved. No issue was framed on that basis.
What were your issues?
Issues are, my lord. In page number 32, my lord.
Yes.
Whether there is a cause of action for the suit, whether suit is maintainable in this present form, whether the suit is barred by
That we have
limited-
seen. Come to 10.
my lord,
Come to number 10.
10, my lord, yes. Whether the counterclaim is entitled to specific performance of contract on the basis of unregistered sale deed dated 8/2/2014 and 30/4/2015.
Those were sale deeds,
These are the agreements, man.
not sale
agreements.
deeds. Where is the sale deeds or agreement to sale?
Agreement to sell, my lord,
Not sale deeds.
not sale deed. Unregistered agreement to sell.
Yeah, do you have a copy of those?
That is, I am very unfortunate, my lord, that
Let us see your pleadings in the counterclaim. Mr. Saikya, are these sale deeds?
No, man.
Agreement to sale?
Unregistered, man.
No, registration, unregistration, that's a different
And it
aspect.
has been denied by us, my in the written statement.
No, no, Mr. Saikya, on the issue of registration, unregistration, it will depend whether it's an agreement or where is the property or where it's a sale deed. If it's a sale deed, then there is no question of go into regarding the registration part.
Well,
But so far as the agreement is
Agreement to sale.
concerned, there may be some debatable issues.
Well.
Now, what was your case?
my case, my lord, we have denied the agreement, that agreement. He has alleged that.
You had denied.
We have not, my lord.
But he says that, Mr. Fukan says that in your written statement to the counterclaim,
Right.
you have not denied, you have only said that it was
We have denied it.
resigned by the
yes, my lord. It is in
defendant.
his plaint, my lord.
We have denied.
In his plaint, he admitted that he agreed to sell the suitlet. It is in his plaint, my lord. It is page number 10, my lord. Para 6. The plaintiff at present residing at Bhing, taking
No, the issue number 10, which was framed by terming these two deeds as unregistered sale deeds. Is it correct? Did you
unregistered,
no, where those sale deeds?
my lord.
No, my lord.
Unregistered, not Sale deed, my lord.
That is what, is it correct? Where does sale deeds or agreement to sale?
Agreement, my lord. Both the London trial court held that it is an
Why is
agreement.
the expression sale deeds used? These have got different connotations. One is an agreement, one is a sale deed. Agreement, there is no transfer of property.
Yes.
Where is your contention in the written statement?
My lord.
In your written statement, where is the contention that these are agreements?
No,
to
my
sale?
lord, I have counterclaim, my lord. In the counterclaim, I
Let us
put it.
see where in the counterclaim.
Counterclaim is at page, my lord. 19, my lord. Para 2, my lord. Paragraph 2, my. 19.
Yes, please.
The plaintiff is owner of the land mentioning above. When the plaintiff possessing his share measuring 2 bigha 2 kotha 10 lesa of that number such and such, number such and such, district Morigaon, plaintiff Biren Bora proposed to sell and settle the price at rupees 4 lakh, and thereafter on 8/2/2014, plaintiff took rupees 20,000 by exiting a unregistered sale deed, my lord, with promise to execute registered sale deed and deliver possession thereof to the counterclaimant, and therefore the counterclaimant requested the plaintiff to taking the balance amount and execute the registered sale deed, my lord. There's some confusion is there, my lord, whether it's amount to sale deed or it is
No,
an
you have used the expression sale deed, but from the narration of facts, it
my lord.
transpires that it was only an agreement to sell.
Agreement, man. Because he promised to execute the registered sale deed.
There are two agreements.
Two agreements, my lord. And those are exhibit co and co.
We'll frame the question on issue number 10.
Fine.
Okay.
My lord.
Heard Sri DCC Fukan, learned counsel for the appellant, who has, please have your seat, who has referred this regular second appeal under section 100 of the Code of Civil Procedure, challenging the judgment and order dated so and so, huh? Dismissing so and so, pura, cost studies. The appellant is the appellant was the defendant in the suit which was instituted for declaration of right, title and interest on recovery of possession, full stop. In the said suit, comma, the appellant had also made a counterclaim, and the issue number 10 relates to the relief sought for in the counterclaim, which reads as follows. Issue number 10, page 32. 10 likhna hai, 10. The learned counsel has submitted that the aforesaid issue has been decided against the appellant by both the courts below, without taking into consideration the evidence on record, full stop. The learned counsel has also informed this court that so far as the same judgment and decree is concerned pertaining to the plaint, comma, the present appellant has already instituted RSA 4 of 2024, which was admitted by this court on 10/1/2024. Full stop. Para. Admit discipline on the following substantial question of law. Full stop. Para. Number mat dijiye, haan, 13 karke. Whether the findings arrived at on issue number 10 regarding the counterclaim for specific performance of contract instituted by the appellant on the basis of unregistered deed dated 8/2/2014 and 30/4/2015 are in accordance with law. Put up any other question, huh? Call for the records. In the other case, records have been called for.
LCR
Yes,
has called for,
call for records in nature, huh? As observed above, comma, the connected RSA 4 of 2024 has already been admitted. Wide order dated 10/1/2024, and the LCR has been called for. Full stop. List along with the aforesaid RSA 4 of 2024 after receipt of the LCR. Full stop. Three para. Three pieces here. Learned counsel is present for the sole respondent and accepts notice.
My lord, I may hand over the copy of this RSA.
Yes, let a copy of the present RSA along with the connected documents be handed over. Be furnished to Sri Saikya
Well,
within 2 days.
well,
All
well,
What is this 53? 53, okay, that is already stayed. No? Okay. And you write in? This was item number. Okay, in RSA 4 of 2024, you write a list along with RSA 12 of 2024. List along with RSA 12 of 2024, which has been admitted today and is referred by the same appellant against the same judgment. Item 13.
Wait, please, Lord. The plaintiff is the appellant here in law. The plaintiff filed a suit for specific performance of the contract. That is the agreement for sale that
Does
is
it come up for admission?
lot for framing substantial question.
Plaintiff,
Plaintiff is the appellant.
appellant is the plaintiff.
Yes, sir.
Suit for?
Suit for specific performance of contract regarding agreement for sale dated 12/4/06.
Suit was instituted when? Madam, anything you would like to say now?
I'm appearing on the first. Lordship, copy may be served. I and appeal copy may be served.
That will come up if Lordship frames the substantial question of law. That is then only notice or otherwise will come.
But suit was barred by limitation, Lordship. And also plaintiff failed to prove willingness and readiness. Under Order 7, Rule 7, specific performance.
So this is the
was
second
not
appeal.
made.
There is no provision for issuing notice actually. Either we frame substantial questions of law or we dismiss it.
If Lordship frames the substantial
But
question of law,
for the interest of justice, without even issuing notice, if you want to make some, but you don't have a right actually.
no, Lord. Under
There's no scope.
section 100 and subsection 4. And very clear. Lord.
Yes, it's very clear.
Now,
Okay. Have your seat. Let us see.
Lordship, the defendant, he executed the agreement for sale for selling 1 katha 4.5 lessons
This
of
12/4/2006 agreement, 12/4
agreement,
Yes.
12/4/2006
for sale of
for selling 1 katha 4.6 lessons of land.
And total consideration was rupees 6,61,500. And earnest money of 1 lakh has been paid on 12/4/06 itself. Now, in this agreement, Lordship itself, the time was not the essence of contract as per the clause of the agreement. And the condition was that the registered sale deed would be executed within one month from the date of obtaining the permission of sale from BTC and on receipt of the balance considered. That is the condition, Lordship. Defendant will obtain the sale permission within 1 month. The registered sale deed will be executed on receipt of the balance amount. Then, Lordship, here, Lordship, the plaintiff is already in possession of the suit land since 31/12/03. He is running a motor garage therein as a tenant of the defendant. Now, Lordship, in the meantime, due to some economic constraint, defendant asked for further money and the plaintiff paid 1 lakh twice on 19/4/06 and 10/5/06. So, balance consideration come to rupees 3,61,500. Now, here, Lordship, the plaintiff, the defendant, along with the 4 persons, has earlier purchased 1 bigha 1 katha 8 lesses of land. That is in 18 to 70. And defendant's share is 1 katha 18 lesser. So he can sell the land to the plaintiff. When the defendant executed this agreement for sale, then one of these purchaser, Lordship, the joint purchaser, he instituted a suit, title suit number 8/2006, along with a missed case on 10/5/06. In that case, plaintiff and defendant made the defendant therein, and they jointly contested the suit, filing written statement. Then, Lordship, this title suit filed by one Sadhana Devnath, 8/2006, it was dismissed on 7/11/13. Then she filed a title appeal, and that was also dismissed on 10/7/15. Now, Lordship, the plaintiff, on several occasions, Lordship, this is a pleaded case, on several occasions, requested defendant to execute the registered sale deed, but taking pretext of pendency of the suit of 8/2006, avoided to execute the sale deed. Then, during pendency of the suit, the plaintiff sent to legal notice on 7/4/09 and 10/6/10, and defendant did not give any reply. Thereafter, Lordship, on dismissal of the suit, plaintiff again approached the defendant, and defendant requested to await for the final outcome of the appeal. Then, after dismissal of the appeal, Lordship, this is relevant. After dismissal of the appeal,
Which appeal? Which appeal?
that filed by the Sadhana Devnath.
Okay.
After dismissal of the appeal, Lordship, at the instance of the defendant, a meeting was held on 19/11/15 at the house of the plaintiff, in presence of some local people, which includes the PW number 2 also. And on that date, Lordship, 19/11/15, defendant refused to execute the registered sale deed. Now, there is specific pleading in the plaint regarding readiness and willingness to sell the land. And also, Lordship, the defendant has violated the terms of contract because he did not apply for the sale permission. Until and unless his sale permission is not obtained, that 1 month will not come, and the paying of the balance consideration also does not arise until and unless. Then, Lordship, the
See, it was a contingent contract that he will obtain the permission.
Yes.
For that, can you wait till infinity that the limitation will keep on extending? You are not supposed to approach the court that get a permanent injunction or a mandatory injunction to get it registered.
But both the plaintiff and defendant, they are contesting the suit filed by the
That is a different matter.
Devnath.
That is a different matter.
Now,
But
Lord,
to show an acknowledgement, to overcome limitation probably is the main ground of
Yes.
defense.
Yes.
Under section 18, it has to be within that period of limitation, number one. What is the acknowledgement has to be very specific. You said legal notices were sent to him,
Yes.
it was not even replied. Even reply will not amount to an
here,
extension. An extension has to be within that period of limitation. Law is very clear.
no, here, Lordship, Article 59 will come, Lord.
Limitation Act.
Article 54, Lord.
Yes, please.
It's for specific performance of a contract.
Yes.
Period of limitation is 3 years.
3 years, yes.
Now here two things are there. The date fixed for the performance. In our case, there is no date fixed for performance. The second part, if no such date is fixed, when the plaintiff has noticed that performance is required, so that refusal by the defendant, that date is relevant here. And it is on that
1911-2015.
1950. That is the date. Here, Lordship, so far as this petition, and Lordship, it was settled position of law that the date fixed referred in this Article 54 has to be a calendar date, Lord. And it has to be determined on
When did you institute the suit?
in 2016.
On when the plaintiff, please come to Article 54 again.
Yes.
The date fixed for performance, or
Or
if no date is fixed,
yes,
when the plaintiff has noticed
is that
that the performance is refused.
Yeah.
Are you trying to contend that it is only in the meeting you had noticed
Yes,
that performance was
that
refused?
refusal. Because, Lordship,
Your legal notice are of 2009, 2010.
yes. Because-
This meeting was held in 2015 November.
Yes, after dismissal of the appeal, because these are pleaded case, Lordship. Since the same suit is involved in this suit filed by this Sarna Devnath, that is why they have waited till the dismissal of the appeal. After dismissal of the appeal, Lordship,
Now, is there a contingent that till the dismissal of the appeal will wait? This agreement is of the year 2006.
yes,
You instituted the suit when? In 2016.
yes. When the refusal has,
That cannot
come
be, it is not you have to notice the refusal. His overt act of refusal is not a notice to, if you have not noticed the refusal. When you see, you perceive that it has been refused, you have to, when no date is there. You had perceived long time back. You had perceived in the year 2009 and 10, where you issued local legal notice.
yes,
How do you overcome that?
yes. Regarding that refusal, Lordship,
Yes.
now, Lordship, this is a reference regarding Article 54,
Please.
before the three judges bench of the Supreme Court, and
Yes,
the
yes.
issue is at 2, para 2,
2009.
2009, 5 STC 462. Para 2, 9, 10, 11, and 12.
Sahab. Para?
Para 2, 9, 10, 11, and 12. Question involved is at paragraph 2, whether the use of expression date used in Article 54 of the schedule to the Limitation Act 1963 is suggestive of a specific date in the calendar. Now, Lordship, paragraph 9 and 10, that definition of date and fix has been discussed. Then
Yes.
paragraph 11.
Yes.
The inevitable conclusion is that expression date fixed for performance is a crystallized notion. This is clear from the fact that the second part, time for which period begins to run, refers to a case where no such date is fixed. To put it differently, when date is fixed, it means that there is a definite date fixed for doing a particular act.
Correct.
Even in the second part, the stress is on when plaintiff has noticed that performance is refused. Here again, there is a definite point of time when the plaintiff notices the refusal. In that sense, both the parts refer to definite dates. So there is no question of finding out an intention from other circumstances. So here, Lordship, there is specific date mentioned. To that effect, the person present therein also it is evident. And there is no whisper in the written statement and the evidence of the DW that he refused on such and such date. Nowhere he mentioned. And Lordship, the in the impugned judgment also, that no date has been determined. That Lordship will find the finding at page 107, Lordship.
One zero seven.
107, issue number 3, that's power by limitation, the finding part.
One zero seven, which paragraph?
It is a part of paragraph 42, Lordship. 42 starts from 106. And I'm reading at 107, this second line. Finally, Lord.
Just a minute. 106.
One zero seven, Lord. Second.
Just a minute. Finally.
Finally, on 19/11/15, in a meeting held in House of Plaintiff at the instance of the defendant refused to execute the sale deed in favor of the plaintiff. He has noticed that, learned trial court. Now 43. It apparent that much before filing of the present suit on so and so, two legal notices were sent respectively by the plaintiff to the defendant for execution of the registered sale deed for the suit land. But the defendant did not give any reply to the plaintiff, which amounts to refuse by the defendant to execute the sale deed. So amounts to, he did not determine what is the date of refusal. Like here it's Lordship says, so there is no question of finding out any intention from other circumstances. And Lordship, all along Lordship, in written statement also, the defendant denied the notice. And in evidence, he categorically stated that he did not receive the notice. So that refusal part, Lordship, only this is the evidence by the plaintiff. PW1 and PW2 is that 19/11/15. And there is no other date mentioned, Lord. Even defendant in his evidence also did not mention any date that he refused on such and such date. Then 12 also, whether the date was fixed or not, the plaintiff had noticed that performance is refused and the date thereof are to be established with reference to the materials and evidence to be brought on record. This is the only date brought on record regarding refusal. So without determining the date of refusal and even taking note of that date 19/11/14, he has overturned the issue decided by the appellate. This is a reversal. trial court decided this issue number 3 in favor of the plaintiff.
Let us see the trial court.
At 64,
Paragraph 15.
15.
Yes.
During argument, learned and counsel for the plaintiff submitted that it is stipulated in the agreement that the defendant shall execute the sale deed after obtaining the permission. In the meantime, the suit land was challenged by Sadhana Devnath in title suit number 8 so and so. The title suit number so and so was finally dismissed, and the plaintiff Sadhana Devnath preferred appeal against his judgment and decree.
These are the narration of facts. 15. There,
Yes.
where is the
Then
finding?
16. The defendant admitted that there was suit bearing number so and so and appeal bearing number so and so where the present suit land was involved. It is also the matter of record that the appeal was dismissed on 10/7/15. Therefore, it appears to me that the plaintiff has filed this suit within 1 year of dismissal of the appeal, and as such, I find that present suit is well within limitation.
But that is not on this issue. That limitation has been reckoned from the date of dismissal of the.
No,
That perhaps is not a correct.
Yes, that refusal that should have been considered.
Considered.
That has been
Appellate
discussed.
court, you may be correct in contending that the actual appreciation, whether it's correct or not, that's a different matter.
Yes.
But 54, the issue, Article 54, if a date is not mentioned, how
Yes.
do you proceed?
Yes.
At least there is some application of mind.
Yes. That is one of the substantial question of law involved in this appeal, Lordship, regarding this part of limitation. Trial court also, Lordship, dismissal, that is not correct. That regarding, Lordship, that readiness and willingness,
Yes.
other question of law, Lordship, that is the issue number 4.
No, see, Mr. Deka,
Look.
if you overcome the aspect of limitation,
Yes.
then those will be matters on merits. Readiness, willingness.
Yes.
First, we are on the considering the limitation part.
Yes.
But still, then where is that issue?
95.
9.5.
So it starts from 9.5 because there is issue number 4 has 2 parts. Issues are at page 93, Lordship. Issue number 4 has 2 parts. Whether the defendant enter into an agreement for sale on 12/4/06 with the plaintiff in connection with the suit land. Regarding this, there are a concurrent finding, Lordship. If so, whether the agreement for sale that is valid and enforceable in law. Trial court decided in favor of the plaintiff, but appellate court, Lordship, though it has held that the agreement for sale is enforceable, valid and enforceable, but it says that it does not fulfill the condition precedent of section 16C of the specific relief act. That is the readiness and willingness. Lordship will find that page 20, page 95, para 20 onwards.
You have not invoked, there is no invocation of part performance. You said that some amount was paid.
Yes, paid. Now,
And you are already in possession.
yes. Now, so far as the readiness and willingness, Lordship, appellate court did not consider the pleading and evidence regarding readiness and willingness. And one thing is that, Lordship, the section 16C is amended after 2018. So he has also gone by that amended because in our case, it is of 2006. So pre-amended section 16C will apply in this case.
This is a defect. Open it.
Okay.
Which provision has been invoked?
Specific relief of section 16C.
This was brought into the statute on 2018, 110.
Yes. That Lordship, it will take this decision, Lordship, this 2023, it is explain everything, Lordship. Similar case like ours.
Let us
2023
Of course,
SCC.
let us very specific personal bars. Now, how will this come in? Even the amended part?
Lordship, Lordship, if Lordship takes up this government, it is explained, Lordship,
Yes.
here. 2023 SCC online SC 442, paragraph 23.
Three. Yes.
The 23 Lordship, this first seventh line, Lordship, it prevents judgment of this court in Tata so and so that the 2018 amendment.
No, we are not on the prospective nature.
Yes.
That is clear.
Yes, yes.
No, even otherwise, when without going into this aspect, even
Yes.
this was if assuming that this was an existing provision of law,
Yes.
how will it be a bar?
No, Lordship, thing is that we have specifically averred regarding readiness, willingness. What learned appellate court is done, he has quoted some decisions of the Supreme Court, and without discussing how the factual situation of this present suit fits in to the fact situation of those cases, without discussing this, without taking into account the pleading regarding the readiness and willingness, this issue has been reversed. And it says here in paragraph.
If you have heard you correctly, you said that you had paid earnest money of rupees 1 lakh
at the time.
Thereafter, you had paid two more amount. So total 3 lakhs
Yes.
was paid out of the total consideration of 661,500.
Yes.
And you say that the one Sadhana Devnath had instituted title suit where you had jointly contested.
Yes.
So why should that question come in? Readiness, that you did not have the readiness and willingness.
That is trial court has decided in our favor, but appellate court says that the readiness and willingness.
I do not think that would be that.
And because
that bar otherwise will also not come because of prospective nature.
Yes,
Even you go by the Transfer Property Act,
yes,
that will not come.
That is one aspect, Lordship. Here Lordship, in this case itself, only two line is there regarding readiness and willingness. If Lordship sees in paragraph 17, it is the submission. However, in the present case, except 2-line pleading that the plaintiff was ever ready and willing to perform her part of contract. On the basis of these 2 lines itself, this case has been decided. Here also, Lordship.
I think 53A will also be to your advantage of the Transfer Property Act.
Yes.
Because you say that you are in possession.
But Lordship, there is a counterclaim. Counterclaim, eviction is there.
Okay.
Tenant. So that eviction order is affecting here. Here also, Lordship, this case in paragraph 26. But
ultimately, Mr. Deka, if you are able to overcome, let us assume you are able to overcome the findings on readiness, willingness. The limitation point, first point.
First point, I will rely on that decision, Lordship. Because it is very specific to run the limitation, at least some determination of the date. That is also not done, Lordship. And there is no plea because there has to be.
Suppose let us go to the extreme case.
Yes.
You said that a meeting was held on 19/11/2015.
Yes.
Let us assume that there was no meeting. Then, How long will it go?
But-
You had issued notice, legal notice, not replied. You may contend that it may not amount to a refusal. In the notice, if in the reply they would have said that no, we are not going to going ahead. Then you say that my cause of
Yeah,
action
I
has
understand,
accrued.
my lord, that,
But how long?
that will depend on the facts of the case to case basis, lordship. Here,
No,
lordship,
that meeting may not.
no, that here, lordship, after the appeal has been dismissed, that meeting was arranged. And there is no counter or rebuttal evidence regarding this meeting, lordship.
No,
Nothing is there in evidence.
we are not doubting the authenticity or what has happened, proceedings of the meeting. Meeting, there was a refusal.
Yes.
But will that refusal, from that point of refusal, will it amount to you having notice of the intention of the defendant not to execute the agreement?
No, that is what, lordship,
Agreement is of which year?
2006.
2006. The Ahmed Sahab case absolutely says that this date has also been determined, has also is required to be determined. Even if the date is not there, from the date of refusal, it has to be determined from that date.
Yes.
There is no ambiguity in that.
Yes.
But it was this observations were made on the particular facts. If you read the facts, you see that that date has got a lot of relevance.
Now, lordship, immediately execution of that agreement for sale. The tribunal has filed the title, lordship, and it has proceeded till dismissal of the appeal. So that fact is here, lordship.
Was there an injunction
Rasco order was
in the suit
there.
by Devnath?
They have pleaded, lordship. I'm not having that order. There was Rasco order, it was vacated also. I'm not having that order.
But it is a fact that you both of you had jointly contested that suit
Yeah.
and even the appeal.
Appeal not jointly, but in the suit it was jointly.
But joint written statement.
Yes.
At least a joint written statement.
So that is the admission is all along there, lordship. There is no counter pleading or evidence. He has all evasive denial is there in the WS, and he set up a case of eviction regarding his tenancy.
Okay, well, we'll admit this.
I-
1 and 2.
He also, lordship, because
Why?
they pleaded the since
What
no
was the wrong of the first in 41 to 31 and 41-22?
Look.
The third question which you have drafted.
Yes.
We'll frame issues on readiness, willingness that perhaps would go, and second we'll have to really, it's a debatable issue. The interpretation of section Article 54 Limitation Act in view of the decision of the Honorable Supreme Court. Heard Sri J. Decca, learned counsel for the appellant, who by means of this appeal referred under section 100 of the Code of Civil Procedure has put to challenge a judgment and decree dated 2/3/2024 passed by the learned District Judge Kokrajhar in title appeal 2 of 2023 full stop by the aforesaid judgment, comma, what is your name, Goranga?
yes, sir.
The judgment and decree dated 9/1/2023 passed by the learned civil judge Kokrajhar in title suit number 2 of 2016 has been reversed. Full stop. The trial court had decreed the suit in favor of the plaintiff, correct?
Okay.
In favor of the plaintiff, full stop. Para. The learned counsel for the appellant has submitted that the reversal on the ground of, on the issue of readiness and willingness, which was the issue number 4, by taking into consideration section 16C, section
Yes.
16 within bracket
Small c.
C of the Specific Relief Act 1963 is not in accordance with law. Full stop. It is submitted that that the aforesaid provision of law came into operation in the year 2018. 18, right? 2018.
Yes.
Whereas the suit was instituted prior in point of time. Full stop. He otherwise submits that the plaintiff could prove his readiness and willingness in the suit. Full stop. The judgment of the First Appellate Court has also been criticized on the appreciation of the law concerned with the aspect of limitation vis-a-vis Article 54 of the Limitation Act 1963. Full stop para. The appeal is admitted on the following substantial questions of law, page 13, 1 and 2. Any other, huh? Call for the records. You're appearing for your name?
D. Pathak.
MSD Pathak, Learned Counsel, has entered appearance on behalf of the sole respondent. Full stop. Let extra copy of the memo of appeal along with all the enclosures be served upon her within 3 days.
No.
List after the receipt of records
There is a need case lordship because
for
title execution case has been filed lordship. It is fixed on 12/6/24 for stay of the execution lordship.
heard Sri এটার উপর লেখা আছে না যে ডেকা লিখিবা এটা লিখিছে নাকি উপর heard Sri J. Deka Learned Counsel for the applicant appellant who by means of this application filed under Order 41 Rule 5 of the CPC has prayed for stay. Full stop para. The connected appeal RSA 83 of 2024 has been admitted today. That is IE date, huh? Para. It is submitted that so far as the counterclaim is concerned, comma, an execution proceeding
Title execution number 2 of 2020.
has been initiated, being title execution case number.
2 of 2020.
But where is your appeal against the counterclaim?
That is why lordship that the substantial question of fee, because lordship there his finding is that regarding counterclaim that there is no cross objection.
Right.
Cross objection is required when the decree is under silence. But if so far as the findings are concerned, lordship, that without the cross objection also that can be that is judgment, recent judgment I have given lordship there.
Yes,
So
that
that
is the point. 832 Diba.
That is why I have-
Yes, okay, yes, yes. That was what we were wondering. 3 number Diba. Huh? Substantial
Divide
questions of
from
law,
the
1 to 3.
judgment
তিনটা
is
আছে।
there. Right.
Okay, এটা কি লিখিলা? Appeal of the substantial question. Number?
Number 2 of 2024, title execution number.
Before 2 of 2024, before the court of
Before this civil judge, senior division, Kokrajhar.
Senior Civil Justice Senior Division, Kokrajhar. Full stop. Para. Since the appeal has been admitted on substantial questions of law, comma, till disposal of the appeal, comma, further proceedings in the title, aforesaid title execution case shall remain suspended.
Obliged. So that consideration number 3
Three we have incorporated.
Obliged.
Three will be required.
required.
Tinta riba substantial question of law. Yes. It will sign code মোটা এখানে দিয়ে দিবা সাইলম তো।
May it please.
Yes, item number
What? Now the matter second appeal pertaining to the land acquisition. Acquisition of land pertaining to certain land, my lord, by the government of Assam, and it was handed over to the Port Corporation of India, my lord, after getting all the compensation. The matter, the fact of the case is that, my lord, the respondent number 1 filed a suit before the Municipal Court, Karimganj, my lord. One of the pair was for a right title and declaration of the third schedule of the land and for the release of the suit land, my lord. So the learned trial court, my lord, framed the.
you have also started to address the court in a second appeal.
Well, the substantial question of law is, my lord.
No, in the second appeal, why are you addressing the court? What is this practice? It's an appeal. Why do you address the court? It's a memo appeal. Appellant is what?
Appellant is my lord, Port Corporation.
No, defendant.
Was defendant.
Defendant number?
Defendant number, my lord. Defendant number 4.
4.
4.
FCI. And suit for?
Suit for right declaration of the right title and interest of the third schedule. That is the suit land, my lord. There is 3 schedule. Suit land is the third schedule. And for the release of the suit land, my lord.
For?
And for the release of the suit land.
Release means?
It is the fair. It is in the fair. To return back the suit land. The land which has been acquired by the government of state of Assam.
Okay, what was
So, my lord, the issues where my lord may come to page number 42. So,
what was the case of the plaintiff?
plaintiff was that it has to be returned, my lord. It belongs to them. So, declaration of their right title and interest and for the release of.
No, they traced their title to which document? How was the title? By which document they have established their title?
They have tried to establish the title by one sale deed, my lord, which is exhibit.
Sale deed from whom?
From the original Pattadar.
Sale deed?
My lord.
Registered sale deed?
Registered sale deed, my lord.
They purchased when?
Can it be taken up on second? I will keep this specific.
Okay, come prepared at 2 o'clock. We'll have.
Yeah.
This land was settled with you
Settled with us, my lord.
by the government.
By the state of Assam, and the trial court has dismissed this suit, saying that it is barred under section 63 of the right to fair compensation and has asked them to claim their.
Was it
compensation.
acquired? Was the land acquired?
Yes, my lord, it was acquired.
Land was acquired.
Land was acquired. my
Okay,
lord.
then
So,
they had challenged the acquisition in the suit.
no, my lord, they have come before the civil court for right title and interest and for the return of this suit land, my lord.
Acquisition is not challenged.
Acquisition has not been challenged. In fact, the trial court has held that that you approach deputy commissioner for your compensation. And in the appellate court, it has been reversed.
No, there is the scope of challenging an acquisition is very, very limited.
No, that is what my case is, my lord.
We are not
So,
saying that.
London trial court has rightly.
If it is for a public purpose, And if there is no
Learned trial court has rightly held.
malafide intent, which is very difficult to prove, you cannot just challenge an acquisition. You can be aggrieved by the amount of compensation
The
for
respondent,
which reference will be there even under the
no,
new.
I am
Act.
not, I am not challenging. It has,
I
it has
know.
come in.
No, we are just making a.
So my
We are
lord,
at 2 o'clock we'll have to come.
Delete number 3363 and 3364 dated 10/6/2005.
By whom?
By the defendant number one from one Mr. Arvindo and Ramdhenu De, the original Pattada.
Okay.
Thereafter, this land was
The sale deeds were of which year?
of 2005, my lord.
2005.
And the land was mutated on 3/9/2013.
Okay.
And the acquisition proceeding was held on 27/2/2013.
27 to 13.
2013, my lord.
Under LA case number?
LA case number, my lord, case number 1 of 2012 and 13. 1 of 2012
And?
dash 13 within bracket RLA 312
Okay.
oblique 2012 oblique 09 dated 27/2/2013.
That is the notification. LA case is 1 of 2012.
1 of 2012. ma'am.
Okay.
And then notice were issued, but since the defendant,
The acquisition was for, you are the beneficiary in the acquisition.
I am the beneficiary.
To have your office.
Yes, we have our FSD, food storage depot. It's a
Okay.
huge food storage depot.
Okay.
Initially, the plaintiff claimed that they were abroad, so they didn't got the notice issued by the government of Assam. Later on, as per the paragraph 15, they have raised objection, and then the government of Assam replied in para 16, and then stated that the land has been acquired and it has been given to the FCI. And now the exemption will not
What
be,
about the acquisition award?
award is not there.
Hmm?
It is not there.
But the acquisition has culminated in an award.
Yes, ma'am. Now, as per their prayer, my lord, they want at least the schedule 3 has to be returned because they claim that it will be our right to weigh, my lord, of the plaintiff and the pro forma defendant number 5 and 6, my lord.
Now, what was the finding of the lower courts?
My lord, there were 4 issues, my lord, framed, that is at page 42.
The trial court had dismissed the suit.
Dismissed this suit that it is a part by section 63, my lord, and also suggested the plaintiff to approach the deputy commissioner, my lord. That is at paragraph 24, my lord, at page 45. Page 45, my lord.
4-5.
4-5.
Yes, what has been held?
Para 24, my lord. I will read just para 24.
Yes.
The plaintiffs have prayed that they have not received any compensation or notice before the suit land was acquired. Therefore, as per the provision of Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation, and Resettlement Act 2013, the plaintiff has been suggested to approach the District Commissioner Karimganj, who shall entertain the complaint of the petitioner as per the relevant provisions of the Act 2013. In view of the decided issue number 2, the plaintiffs are not entitled to get any declaration of their right in respect of the third schedule of the land from this court. So the suit was dismissed. In the appeal, the lower appellate court has, my lord, appellate court has reversed the judgment, my lord.
Issue number 3.
That was issue number 2.
Where is the judgment? Page?
Lower appellate court, my lord, the judgment, the operative part, my lord, at page 57. Page 56 is the issues which has to be which has been decided by the framed by the lower appellate court.
Why are you so late in coming? There was delay condonation or what?
Yes, ma'am. There was a delay condoned.
Okay, the delay has been condoned.
Yes, ma'am. 2 weeks ago, it was condoned, ma'am.
Okay. Yes.
So lower appellate court, my lord, at page 56 has framed two issues, point for determination. One is down below, my lord.
Yes.
Whether the plaintiff and performer defendant number 6 has right title in interest. Number 2, whether the impugned judgment and decree required any interference. So lower appellate court has, my lord, decided that it is the plaintiff is entitled for the return of that third schedule, my lord, third schedule land, and my lord may come to page 62.
62? Yes.
Just above the point number 2, my lord, plaintiff has successfully proved his title over the Schedule 1 land by adducing necessary evidence, and also proved the fact that the Schedule 3 land is very essential part of the rest portion of the land. Page 60.
Yes.
Thereafter, point number 2, whether the impugned judgment and decree required any interference. That is paragraph 23. In view of the discussion, it is concluded that the impugned judgment passed by the learned court is not found correct in law as well as fact. As such, appeal is allowed on contest. The impugned judgment.
Okay, what are your substantial questions?
My lord, my substantial question of law at page 3, my lord. I have framed 5 substantial question of law. Whether the suit is maintainable for declaration of right title and interest of the suit.
Page 5.
Page 3, my lord.
Page 3.
1 and 2 can be covered in one issue, my lord. Substantial issue, as it is barred under section 63.
Even some the Land Acquisition or not 2013 Fair Compensation Act. Right to fair compensation for the
My lord, the new act, right of fair compensation. 63. No civil court other than High Court under Article 226 and Article 227.
How was this point taken?
My lord?
How was this point considered? Was this point considered the bar of-
Yes, in the trial court has considered this point, section 63, that it is barred, and you have to approach the deputy commissioner.
Now, the appellate court, how was
It has not considered. In fact, a lower appellate court has said that since there is a disputed question that we have disputed his title, so it comes under the
No,
title.
is there any ambiguity or any dispute regarding the portion of the suit land being the part of the acquired land?
No, there is no dispute.
Heard, Sri B.K. Singh, Learned Counsel for the appellant, who by means of this appeal filed under section 100, preferred under section 100 of the Code of Civil Procedure, has put to challenge a judgment and decree dated 16/11. It is cost title for review, it is page 1. So it is submitted that the suit land in question was the subject matter of an acquisition proceeding pertaining to LA case number 2 of 1213.
1 of 2012 and 13.
Is it
Yes.
1 or 2?
1, my lord, as per paragraph 13, my lord.
In yours, the substantial question of law, you have written 2. Why? LA case number 1 of 2012
1 of, my lord.
13.
It is 1 of 2012.
Within bracket RLA 312/2012/9 dated 27/9/2013, and therefore which is not disputed, and therefore there was a clear bar in section 63 of the right to fair compensation and transparency in land acquisition, rehabilitation and Resettlement Act 2013. Full stop. It is also contended, it is also submitted that the aforesaid aspect was rightly appreciated by the trial court, and without there being any discussion on that issue, the suit has been decreed by the first appellate court. Full stop. Para. Admit on the following substantial question of law. Page.
Four also, man.
Whether the suit is maintainable in view of the bar under section 63 of the so-and-so Act, 2013. Number 2, Diva. Or any other, call for the records. Let Sri K.K. Bhattacharya, London State Council, accept notice on behalf of respondent numbers
2, 3, and 4.
2, 3, and 4. Let extra copies of the memo of appeal along with the enclosures be served upon him within 2 days. Let steps be taken for service of notice on respondent numbers 1,
5, and 6.
1, 5, and 6 by usual process. Steps within 3 days. Para. List after 6 weeks along with report on service.
Obliged.
No,
I have, my lord, that we are in the position, my lord, and plus there is no execution bank. After taking instruction, we will take that.
Okay.
Obliged, man.
15.
Mr. Jain, which is your case you're waiting for long? What is the matter? Item number?
26.
Now, what is the stage?
Substitution
No, condemnation, notice has gone or what?
for petition, sir.
No, has notice been issued?
Now, my notice has been issued.
Now you're opposing the condemnation?
Yes.
Okay, we'll hear you after some time. Wait for a while. Yes.
Okay, we are the defendant
Yes.
in docket Manipur number 84.
Oh, today, but we are rising at 3 o'clock. I think there's a reference. 3:15. Okay.
Docket, we are the defendant in a money suit 84 of 2014 for realization of rupees 1,05,000 odd. Suit was dismissed by the trial court on the ground that during cross-examination, plaintiff witnesses stated that he do not know what has been stated in the evidence on affidavit, as well as suit was barred by limitation. He has admitted during cross-examination that
You're the defendant.
with the defendant.
How many appellant? One. One appellant.
No, suit one applicant.
Defendant. Suit for the recovery of money.
Money loan. Money of rupees not so much, 1,05,271.
So why didn't you pay if it is not a big amount?
Not big amount, but it's emotional involvement is there that is well.
Emotional aspect.
Some emotional involvement because there a huge transaction was there with the the plaintiff, and there are some for discount and other things. There is a clash. That is why. It was filed by the Sunny Steel. Lotte is aware Sunny Steel. There is a farm for supplying the hardware methods.
Sunny or Sony?
Sunny Steel.
suit was filed by the plaintiff, and Lordship will find page 91. Page 91 is the dismissal order.
How do you pronounce in Assamese? Honi,
Sorry,
not Soni, Honi.
sorry.
It's not Sunny.
But they are saying Sunny State. Everyone thinks Sunny State.
Okay. What does Honi wants from us?
Lordship,
Oh,
Sunny
you are
wants-
against Honi.
Lordship.
You are fighting against a dangerous opponent. Luckily, today is not Saturday. You are the defendant.
No.
Suit for recovery of money.
Recovery of money of rupees 1,05,271.
1,05,271.
Look.
Who PW says that he's not aware of the chief.
Fact, what has been stated in the evidence?
PW1.
PW1. Only witness.
Okay.
And
Does
he
not
has
know-
also admitted that there is no acknowledgement by this time when their debt was for 2009, suit was filed in 2014, and there was no acknowledgement.
2009 was the transaction. 2014 suit filed.
Suit filed.
So you say it is barred by limitation.
And they have admitted during cross-examination
Hmm.
that there is no acknowledgement within 3 years from the date of last transaction.
So no section 18.
No section.
Yes.
And trial court Lordship will find page 31. Trial court has recorded the statement.
Trial court dismissed the suit.
Dismiss the suit.
Then what happened to the appellate court?
Appellate court held that defendant has examined as a defense the DW, and during cross-examination he stated that rupees 1 lakh was paid. Rupees 1 lakh was paid to him during the gap period, and that gap period was considered. It is not a transaction of this amount. That is also examined. That was also admitted during cross-examination. That is not a transaction of this transaction. But appellate court has said that 1 lakh is a time period within this gap period.
So it will amount to extension, acknowledgement of debt.
Acknowledgement of that. And finally, suit has been decreed.
But you say that that amount is not connected with this amount. Where is the finding? Is there any finding?
Page 91, kindly see before that.
9-1,
Page 31.
3-1,
31 of the trial court judgment.
3-1,
Because I am
31.
sorry, Lordship, today I have not the evidence. Copy of the evidence today I do not have.
Doesn't matter. Okay. 31, yes,
Last portion handwritten Lordship, by the trial court.
yes.
PW1 during cross-examination of the deponent and admitted that evidence on affidavit is incorrect or not correct. As such, under section 58 of the Evidence Act, it is need to be proved that the evidence of a plaintiff number patent was not correct. It is not admitted. It is not admitted fact. It is admitted fact. It is an admitted fact. Furthermore, the document adduced and exhibited by the plaintiff within evidence on affidavit are also
Regarded as correct.
as incorrect. Regarded as incorrect. Evidence adduced by PW2 is not sufficient to prove the condition.
PW2, there were one more witness.
Lordship one.
There
As
was one
such,
more
plain-
witness.
Lordship. Plaintiff fails to prove his case, and by adducing sufficient evidence,
Now,
Yeah.
where is that part of the evidence or finding that the amount which you had paid in the meantime?
in
what
the
is-
appellate court, Lordship will find the appellate court finding.
Which page?
Lordship will find in the appellate court judgment, it starts from page 10.
Hmm.
Lordship will find page 15,
1-5.
1-5.
Yes, please. Yes.
From the evidence of PW1, it reveals that he had claimed an amount of rupees 5,02,662 was due from him, the defendant, for business transaction on credit basis, which took place period of 8 September 2009 to 13 November 2009. It was further submitted that towards the liability of the defendant, he made payment of rupees 2,50,000 between the period 2015-11-2009 to 19-11-2009. That for payment of the remaining outstanding dues, defendant issued a check of rupees 2 lakh, which was bounced. The above testimony of the plaintiff remained unrefuted by DW1 Gangadhar Kalita. Proprietor defendant number 1 in his cross-examination has admitted the claim of the plaintiff to the effect that 4 number of business transactions took place between him and the plaintiff in 2000.
Yes, where are your substantial questions?
Subsequent question of law, I have Lordship this frame at the Lordship the initial page, Lordship. Third page. Fourth page. Before the appeal note.
But there were two witnesses, you had said, PWs. If PW1 goes, what about PW2?
PW2 has not stated anything regarding the liability. He also stated that I do not know the actual transaction.
Okay. Heard. Sri S.K. Goswami, learned counsel for the appellants, who by means of this appeal filed under section 100 of the Code of Civil Procedure has put to challenge a judgment and decree dated 30/4/2022 passed by the learned
Civil judge number 2 Kamrup.
Civil Judge number 2 Kamrup, decreeing the suit and reversing the judgment and order dated, judgment and decree dated 29/5/2017 passed by the learned Munsif number 2 Kamrup M in Manisuit number 84 of 2014, full stop. It is submitted that both the aspect of want of adequate evidence and the point of limitation have been misconstrued by the First Appellate Court. Full stop. Para, admit on the following substantial question of law. Number 1, whether the finding of the learned First Appellate Court is in the context of the lack of, in the context of the evidence of the PW1, which was the principal evidence and was, which was stated by the said PW1 in the cross-examination as that he was not aware of it, could be taken into consideration. Full stop. Number 2, whether the bar of limitation was, whether the aspect of limitation was properly appreciated and the findings thereon are correct. Any other, let steps for service of notice be taken upon the sole respondent.
Lordship, no, sole respondent.
Sole respondent by usual process within 3 days. List after 6 weeks, along with report on service. Execution has started.
Lordship, the execution has not started, but I have filed a petition. Only thing is, Lordship may not state this matter at this stage because Lordship in conversation petition they have appeared. Their name has been, I have not verified whether name has been shown in the call list or not.
Okay.
Lordship, that is why, Lordship, I do not pray for stay at this stage. Let them appear.
Okay. The in the IAU, right? The learned counsel, Sri S.K. Goswami, for the applicant, praised for deferring the consideration of this application, and praise that the same for consider full stop. The same would be considered on a later date when pressed.
Lordship, I will take a step or I will inform them to keep a copy.
We have asked you to take steps by usual process. You can inform them on your own. That's a different matter.
Obliged.
It would be better if you inform them since they had appeared in the delay
Because I have not checked out. Just I have checked out the name has not been shown. Obliged.
No, in an admission, otherwise also.
They have no right. They have no. Obliged.
Oh, no, I'm sorry on this.
Okay. Regarding higher number, my lord.
Language খরচা হয়েছে ঠিক করে দিন
হ্যাঁ।
matter, huh? Yes. 22.
Earlier, Lord, while admitting the appeal.
Yes,
because
appeal
it-
has been admitted.
Yes, the first so as to, with respect to possession of the land of the party, that order was passed. My lord, that petition may be disposed of, my lord. Giving the status quo order and final,
Yes.
absolute. death.
4028.
That is 4028.
Okay, that will go. You're you're for the respondent.
I'm for that.
Okay. Anything you want to say on this? Appeal has been admitted.
Yes.
We'll maintain the status quo.
That may be disposed of.
408, huh? Heard. Miss M. V. Devi, learned counsel for the applicant. Full stop, also heard. Sri R.K. Jain, learned counsel for the opposite party, numbers 1, 3, 5, and 9. Full stop. In this I, comma, guide an order dated 12/12/2018. An order of status quo was directed to be maintained, which has been extended from time to time
That's
and is continuing. Full stop, para. This court is of the opinion that since the appeal has been admitted for hearing, comma, interest of justice would require making this order of status quo absolute till the final disposal of the appeal. Full stop. The order of status quo is accordingly made absolute till the disposal of the appeal. I disposed of. Yes, next.
Next, I am, my lord, 240.
2439 is substitution petition.
That was, my lord, the limitation of that one was condoned, my lord. And regarding substitution of appellant number 5, late Vijay Datta, his legal heirs are already, I have mentioned, that may kindly be substituted.
Okay, Mr. Jain. Okay. Heard Ms. B. Devi, learned counsel for the applicants who by means of this application has prayed for substitution of the applicant number 5, Vijay Datta,
Yes.
by his legal heirs. Full stop.
Five
It is, yes, it is submitted that during the pendency of the appeal, comma, the appellant number 5, Vijay Datta, had passed away on 14/10/2022, and the application filed for condonation of delay in filing the substitution petition has already been allowed. Full stop. Para. Also heard Sri R.K. Jain, learned counsel for the opposite parties. Full stop. Para. On hearing and on consideration of the subject matter, and also taking into account that the right to sue survives, comma, the instant application is allowed. Full stop. Accordingly, the legal heirs of appellant number 5, Vijay Datta, who are named hereinafter, be substituted as appellant numbers 5(1), small 1, 5(2), and 5(3), 5(3), 5(4). 5(1), 5(2), 5(3), 5(4). On the death of her. I accordingly stands allowed. Para.
Next, my lord.
1 second. The applicant is accordingly directed to file amended cause title in the connected RSA number 309 of 2018, which could be done within a week from today. Yes.
Next, my lord, 3850. This
Yes.
is condonation petition for 637 days. I have objection regarding
637 days in
filing a substitution petition.
My lord,
no
regarding,
substitution you have already allowed. If you are
No,
objecting,
only in one case.
My lord, no, my lord.
Somebody else has also passed away.
My lord,
Yes.
Who has passed away?
Respondent number 4, Narayan Pal.
4 has also passed away. Have you
Yes.
filed objection here?
Yes,
Okay. How many days delay?
637 days.
This is respondent
he
number
has
4.
already filed objection, my lord, in RSA number 306. Next RSA. Both are same, my lord, by common in being order. My lord, regarding 306, substitution of legal heirs of respondent number 4 and 10.
Hmm.
My lord, 10 are already, legal heirs are already on record, so it need not require to be submitted at this. Then, my lord, respondent number 4, Narayan Pal, my lord, regarding RS number 306, my lord.
Hmm.
My lord, in that case, my lord, he has already filed objection, my lord. Affidavit in reply, he has already filed. And but so far, my lord, the IA number 3850 and 3851 are concerned, my lord. Same, my lord, regarding substitution of legal heirs for respondent number 4, my lord. Why these two IAs were filed delayed, my lord? Why it was delayed so much, my lord? What happened, my lord? As per his information before this honorable court, I have collected, he has submitted me death certificate. Then, my lord, we have collected legal heirs. Then we file all the,
No, legal heirs have to be intimated by your colleague under 10A. 10A, it's not the death certificate, it's the details of the legal
It's the
heirs.
information.
He must have given the information.
it is information, my lord, he has submitted me the death certificate. Then we have collected the legal heirs and file.
No, where you got to collect? After he gives the information, you need to file an application. It
No,
is
legal-
for substitution of
legal heirs,
respondents.
legal heirs, my lord, legal.
Legal heirs, information he'll give under 10A. What is 10A?
Only death certificate he has supplied to me, my lord.
10A, he's not supposed to give death certificate, it's the information. Please come to 22. 10A.
10.
10A.
10A.
Duty of pleader to communicate to court death of a party.
Yes, whenever.
Whenever a
pleader-
pleader appearing for a party to the suit comes to know of the death of that party, he shall inform the court about it, and the court shall thereupon give notice of such death to other party. For this purpose, the contract between the pleader and the deceased party shall be deemed to succeed.
Okay, okay, thereafter you collected.
Yesterday I have submitted, my lord, legal
Yes,
heirs.
okay. Now you collected the
File
details,
petition, yes.
details of the legal heir and
Yes, yes.
submitted.
Thereafter, my lord, I file all the IAs, my lord, and handed over it to my clerk. But my clerk, my lord, filed 2 IAs in respect of RSA number 306. And so far RSA number 309 is concerned, he was under impression that he filed IAs in this case also. But after contrary, when I inquired the matter and seen that,
Now in
that two
306,
petitions were
in
not on record.
306 substitution has been allowed.
No,
No, no.
Oh,
because
That
due
was
to
not, that was
condonation,
not
it
on
was-
record, my lord. Again, I had to file. My clerk, my lord, has sworn affidavit, my lord. And again, I had to file
now,
these 2
madam,
IAs.
madam, one thing. Your explanation may be valid for 309, that by mistake, he did not file for 309, but he filed for 306.
Yeah, that's
Let us
right.
consider 306 then.
306, that may be, my lord. He has filed objection in 306. That may be
306,
required.
how many, what is the delay?
Delay, my lord, 60.
Same delay.
No, no,
No.
no, no. In this case, my lord,
In this case-
309, delay is 2018 days.
Oh,
because of that.
2018.
18 days.
Yes.
Okay, and in
And,
the other case,
And my
609,
lord,
where you had filed your,
In both the cases, I filed objection.
and my lord, 306, my lord, the delay is not so much delay, my lord.
then you have to
Only
also,
602 days.
no, you have to file setting aside abatement. Have you filed?
If it is there to file objection in
No,
case
no.
of 609.
I filed in both the cases.
No, this has been abated.
Yes, ma'am.
My lord, I have,
That's
no,
right.
no, no, I have already filed, my lord.
No, filed when? Delay of how many days?
Yes, my lord.
When does it abated?
Yes, yes.
In the 306, 637 days already.
Already
abated.
abated.
Yes, filed only
I
condonation
filed,
petition,
I
nothing else.
filed this composite petition by setting aside
Cannot be composite.
condonation of delay by setting aside abatement, my lord.
Where? Can you
My
tweet?
lord,
Can I tweet?
yes, yes.
Composite petition cannot. be.
These are independent prayers. Have you paid separate court fee?
My lord, I filed two petitions. One is condonation of delay by setting aside abatement, and the other is for substitution.
No,
Composite
no.
petition, I have.
Setting aside abatement is a different concept.
I filed.
Delay condonation is a different concept.
Has already been delayed, my lord.
So you have
If
to,
your lordship allow me, then I can file for the petition for setting aside abatement, but I filed to court fee, my lord, in a composite petition.
you have filed two court fee.
Yes.
Let us see. Now, if you have filed two court fee, then probably.
Well, let the matter come in other days, my lord. I have to inquire the matter, my lord.
Okay,
Where I
you
put it,
you
I
check,
could not trace, my lord.
you check the matters, madam.
Yes.
These orders which are passed today will remain. In the other, you check the matters and we'll try to, then we'll hear Mr. Jain and we'll pass
Yes,
the order. Rest of the matters, on request, list after a week.
Yes.
Okay. আমার কেটা গোল ইয়ারে দুটা গোল নাকি কেটা গোল না না কেটা হে গোল এক দুটা হয়েছে নাকি ওকে ঠিক Yes, Mr. Sharma.
This appeal by the respondent number, defendant number 7 and 8. The
Just a minute, please. Appellants are defendant number 7 and 8.
7 and 8.
Okay.
They have died, but there is a
Okay. Okay. Suit for?
it is a suit for partition by the plaintiff.
Yes.
Suit was decreed on appeal. The appeal allowed. Thereafter,
Suit was dismissed.
suit was dismissed.
Oh.
No, suit was decreed. Appeal dismissed.
Oh, that means concurrent finding.
No, thereafter they prepared an appeal before the High Court. High Court remanded the matter.
No, suit decreed in favor of the plaintiff.
Yes,
Then you filed an appeal.
yes,
First appeal by you.
Yes.
Appeal dismissed.
appeal dismissed.
Affirmed.
Apart.
Okay.
Thereafter prepared an
You came before the High Court.
High Court.
Oh.
High Court framed High Court remanded the matter by framing 3 issues.
Yes.
These 3 issues your lordship will get.
Page.
Page What? 67. These 3 points were formulated by the High Court and remanded the matter to the trial court.
Yes. No, these were the issues. Where is the formulation by the
Page 70.
70?
Yes.
Now, can you take us to the earlier order passed by this court where issues were, where certain
Yes.
points were
High Court.
framed.
Yes, I have it. This is the judgment passed by the High Court.
High Court, okay. Hmm. Going on the fact, three issues are framed. A, B, C.
AB.
Okay. Whether the plaintiff has any title whatsoever. Okay. Then
Then, my lord, the trial court, after remand.
it was remanded to the trial court or first appellate court?
Trial court.
Trial court.
Trial court recorded the evidence of both the parties. And the learned trial court
Hmm.
partly decreed the
Yes.
partly decreed the suit, and the shares of the parties were divided according to the order.
Yes.
Who will get what?
Yes.
Thereafter, on being agreed, the plaintiff preferred an appeal.
Plaintiff.
Plaintiff preferred an appeal. In the appeal,
Yes.
and we also, the appellant also preferred a cross objection before the appellate.
Okay.
The appellate court disposed of the holding that the cross objector, that is the appellant here, they are not entitled to get any share. Because I have exhibited one exhibit, that is exhibit 1.
Appellate court held that you are not entitled to any share.
And
And
my
so far
cross,
as the appeal of the plaintiff is concerned, it was allowed.
that is also partly disposed of. Share has been demarcated.
And your cross objection dismissed.
My cross objection. The plaintiff also preferred an appeal before the High Court.
After
Well,
this
like-
judgment. After this judgment.
Yes, against this judge.
Yes.
And that appeal has been admitted. Our case is this. We got the land from the 2 heirs, that is the Mohanlal and Shiv Prasad. They gifted the land to the present appellant. The gift deed was executed by before the sub-register of it. But the sub-register did not endorse the signature of one, that is Mohanlal, who was found to be in sound mind. That is, and that gift deed was executed as exhibit 1. Now the question is whether the deed of gift was executed and registered. And so far Mohanlal part is concerned, he was not allowed to sign. Whether by that agreement, by the deed, I will get the share or not.
The person who was found to be unsound mind, who was he?
He was one of the son of the main.
No, with regard to the gift deed.
He is one of the heir. He is one of the landholder. Brother.
No, the gift was given by whom? Who had executed the gift deed? This particular person?
No, 2 brothers executed the gift deeds in favor of the appellants.
Yes.
And the sub-register.
And the person who was found to be of unsound mind, how is he connected with this gift deed?
He is the brother, he is the inherited property.
He was not one of the executors.
He was the executor, but his signature was not accepted and he was not allowed to sign.
then if without a partition between those brothers, how can a gift deed be given if one person is of unsound mind?
That is the point to be looked into. Because the gift deed was registered.
It was registered.
Yes.
No, Mr.
As
Sharma,
per
Mr. Sharma, you have just now, you have submitted that the sub-registrar had raised certain objections on the soundness.
Unsoundness of the one of the executive.
Yes, and then after
But
such,
he executed he registered the gift. If the registered is gifted, so far the unsoundment concern is excluded. The other portion I still get.
but was there a partition of the properties between the two persons? There was no partition. How will you determine which part would be a valid portion of the gift deed? Which part will be of that
No,
person?
that is the partition. This property belongs to the executor of this gift. This is one of the substantial question of law. That is the executive umma. My lord, I have also, apart from the substantial question of law, I formulated, I have also some additional ground. This unsound mind executor, he was a defendant in the main suit. Defendant number 3, Mohanlal. In the main suit, he was not represented by by the natural guardian or any other next
friend. Okay.
Therefore, that suit itself is not maintainable. Under Order 32 of the, if that suit is not maintainable, then subsequent decree and orders will go.
But that suit has attained finality after determination by this court and remanding.
No, well, even though that point can be taken up in the second appeal also, because the second appeal is a continuation of the suit.
No, that is okay. But this, see, there are two.
No, that point was not raised before the trial court. But admitted position is this: he was unsound mind at the time. He was an unsound mind. He was a defendant, and he was not represented by natural guardian and expert. Whether that decree can be effective.
Now, this decree, which you are now trying to, so you're making a submission, is the initial decree in which there was earlier an RSA, or the present decree which has now come up?
No,
with the
it is a continuation. That the RSA decree and the same suit.
That will have a.
And my lord, the point number 2.
What is the context of section 23 and 24 of the Contract Act?
My lord, that 23 and 24 is not applicable here, my lord. Your lordship can look to section 23. Section 23 Contract Act. What consideration and object are lawful and not. The consideration or object of an agreement lawful unless it is forbidden by law. Is of such nature, if permitted, would defeat the provisions of law, is fraudulent, involve or implies the injury to the person or property of another. The court regards the immoral and oppose the public good. That is 23. And 24, agreement is void if consideration and object unlawful in part. These two sections are not related to, so far our exhibit is And your lordship also look to point number 2 of my ground. Whether the learned lawyer appellate court erred in law in dismissing the suit, holding that the plaintiff has no legal character or claim of partition of ancestral property during the lifetime of his father. A person cannot claim the property by way of partition during the lifetime of his father because
No,
in
it's ancestral property.
this father
This-
was his father
They are governed by which law?
Dayabhaga law.
If they are under Dayabhaga law, why not?
No, their father, their right to property will accrue after the death of father.
No, it's ancestral. It's not the father's property.
It is father's property.
No, you have written ancestral properties.
No, it is a father's property. Page 76, your lordship can see. Page 76.
76. Yes. Yes.
Hence, under the facts and circumstances, I only considered opinion that the plaintiff cannot have any title whatsoever to the property left behind by Bhagavan Das and his father Siblal Kanu while alive and was alive when he raised the aforesaid issue, the institution of the title suit number 22. Nor did the plaintiff has any legal character to claim the partition of the ancestral property during the lifetime of his father. Accordingly, point is decided.
You have said that the other appeal preferred by the plaintiff has been admitted.
Admitted. I have the copy with me.
What is the number?
RSA 92. This is the
92. Oh, no, not required. 92 of 2000?
24.
Admitted when?
Your lordship.
No, admitted when?
Admitted on 5/6/2024.
Yes, let us have it. 562024. Can we have a look? Okay. Heard Sri A.C. Sharma, London Senior Counsel, assisted by Sri G. Bharadwaj, for the appellant who has preferred the present appeal under section 100 of the Code of Civil Procedure against a judgment and decree dated 7/12/2023, passed in title appeal number 28 of 2019 by the learned civil judge within bracket senior division Dhubri. Full stop. By the aforesaid judgment, comma, the title suit, the learned first appellate court, by the aforesaid judgment, has affirmed the findings of the learned trial court in the judgment and decree dated 29/6/2019, passed in title suit number 325 of 1986 by the learned Munsif number 2, Dhubri. The upon hearing, the appeal is admitted on the following substantial question of law. Page 5, number 1, Number 1. And we'll have the additional substantial question number, second number 2 as the second one. Okay, right. Or any other, third number, any other question, Let
The first one also important, madam. It is a purely a question of law, but
in the second round, after it has gone back from the High Court, it will be difficult. We are leaving it an option. Any other? Let them come. Let steps, and I call for the record. Let steps for service of notice be taken against the respondents by usual process. List after 6 weeks along with service report, full stop. It is submitted that the plaintiffs had also preferred RSA 92 of 2024 against this same judgment, which has been admitted on 5/6/2024. Full stop, para. List this appeal along with RSA 92 of 2024.
clear.
Can you take this back? এইটো 2 নম্বৰটো আহিব এডিশনালৰ আৰু সেইটো কৰিছিলো এইটোৰ 1 নম্বৰটো আৰু এইটো 2 নম্বৰ দুটা হ'ব মাজত থৈ দিলে
Item 48, same error.
Yes, Mr. Sharma, what is this?
May I please, your lordship. The petitioner before this honorable court is
You have a interim order already in your favor.
against me, lord.
Huh?
The impugn order is that.
No, interim order is in your favor, interim.
Yes, lord.
Now, who's for the other side? Arfukan. Arfukan. Now, if the interim order is in your favor and is continuing, we should hear the other side.
Yes.
Either we make this absolute or we take. Maybe he is not aware. Upgrade করার কথাটো কম জানিব নেকি নাজানিব পাৰে ন কি বুলি আছে সেইবিলাক আগতে ল'ম বুলি ক'লেতো দিগদাৰী হ'ব এতিয়া নামাতিব আগতে পোৱা নাই না কৈছা নেকি ৰাতিপুৱা ক'ব লাগিব না in absence of the other side it will not be proper okay otherwise we have the interim order if it's not taken up we'll extend it don't worry.
First, an observation may be as because the matter has been listed that before the trial court, lord. The matter may be kept in abeyance.
No, there is an interim order.
But matter is listed before the trial court, lord.
How does it make any difference?
We have to furnish the.
No, cannot make the interim order absolute without hearing the other side. They have entered appearance.
Till disposal of the present revision petition, lord. That observation.
No, that will be amount to making it absolute. It's an interim order only for the time being. You file an Hajira, what is the problem? Which court?
At Golaghat.
Golaghat, you entrust a local lawyer, or you go to Golaghat, have a vacation every time. If he doesn't reach it, I'll reach no it will likhiri paucity of time, huh? Interim order stand extended till the next date of listing after a week. Okay. Item number 48.
49 and 50.
No, orders kena mata niki ase no. No, orders kena mata eta enake thik na hobo noy. Very good. Order not. Time I know beshi. Yes, item 17, 2005 matter. Railways. None appears. Railways. None appears for the appellant on call. On the last occasion also, that is 1/12/1/5/2024. None had appeared for the appellant, and this court had made an observation that in case of further non-representation, consequential orders will be passed for para. Considering that this appeal is of the year 2005, the same is dismissed for non-prosecution. 18. Item 18. Again, 2008 matter. None appears for the applicant on call. Full stop. This review petition was filed in the year 2007. Para. The office note, the order dated 5/6/2024 of the Learned Lozima Court indicates that in spite of sufficient opportunities, comma, steps for service of notice upon the sole respondent have not been taken. Full stop. Para. In the interest of justice, comma, let another opportunity be granted, directing listing of this matter on Wednesday, day after tomorrow. Full stop. It is however made clear that in case of further non-representation, comma, this court would be constrained to pass appropriate orders. Wednesday.
Hey, please, Lord. My lord, in this case, my lord, as per order dated 13/9/2019, my lord, I have written to my client, my lord, to communicate with me to take steps because the earlier steps has been returned answered, my lord. But no response has been received, my lord, from the client. And recently, my lord, I have sent another letter on 5/6/2024. Let the matter be come up after 2 weeks or 3 weeks, my lord.
Last time we had granted 3/6/2024.
My lord.
You said that for the last 5 years, you are not in touch
My
with the
lord,
clients.
the client is not, I do not know whether he is alive or not also because he is aged about 90 years, my lord.
Your colleague had very fairly stated on the last occasion that 5 years you have been trying.
My lord. My lord.
And you, in fact, you would not like to continue. That is their submission. Okay. This matter has been listed pursuant to the order dated 3/6/2024. Full stop. For the sake of convenience, comma, the aforesaid order is extracted here and below, 3/6/2024. Para, Sri PC Day, Learned Counsel submits that the situation is the same. And on the last occasion, comma, this court had recorded the submission that the State Council would not like to continue in absence of any further instructions. Full stop. Para, Muscade Yadav, Learned Counsel is present for the response numbers 1 and 2. Full stop. Para. Since sufficient opportunities have been granted and in terms of the earlier order dated 3/6/2024, comma, the present I stands dismissed for want of prosecution. Full stop. Consequently, the connected CRP is also dismissed. Do it at highway 2-0.
My please, Lordship. As per official note dated 6/6/2024, Lordship, LCR in respect of title suit has been received, but in respect of title appeal is not received.
You are for?
I'm for respondent for 120, your Lordship.
Or
Lordship,
the-
respondent number 1 has expired, your Lordship. So we have submitted a copy.
Okay, let us hurry up.
Item number 20.
Laskar, you're for?
PK Deka, your Lord.
No, the name of the case is J N Laskar. Are you for J N
PK
Laskar?
Deka is also there, Lord. I'm for respondent, your Lordship, on behalf of PK Deka.
No, doesn't matter. 3 respondents.
Lordship.
First one has passed away.
Yes, your Lord.
Give him the details if you have.
Lordship.
And okay, it appears that though the records of title suit 62 of 2010 has been received, comma,
Legally.
those of title appeal number 14 of 2024 have not been received. Full stop. Para. registry to issue reminder. Full stop. Para. This court has also been informed that the respondent number 1
Yes, Your Lord.
has passed away in the meantime.
One legal head is there.
Para. Sri has informed by your name?
P. Demari, Your Lordship. On
P.
behalf of
Demari, okay.
TKD.
By Sri P. Demari, Learned Counsel, that the respondent number 1 has, yes, sir, passed away in the meantime, sir. Para. Sri S.D. Purkayastha, Learned Counsel for the appellant, accordingly pays for and is granted 3 weeks' time to file application for substitution. Okay.
Problem.
Any case where interim order is still today?
Lordship, in item number 32, Lordship, the interim may kindly be
30?
32.
32 interim.
So, Lordship, item number 53.
Sir, interim.
Lordship, item number 40, I for correction, Lordship, on last occasion due to posterior time.
He'll give a date,
Lordship.
short date, okay?
Item 52, my lord, interim there.
52. Okay.
Interim, I- 51.
Interim. Okay.
Lordship, item number 56, it may be listed on Friday.
So date, court master will give, okay?